Okay, while everybody's joining, and everybody's logging in and getting in here, let's talk about a little bit about our agenda today. Saskatchewan, Algeria, Haiti, Mississauga, yay, Winnipeg, wow. Some people did not receive the recording. I will be, you know how all this email science works. Sometimes emails go to spam. If you did not receive the recording, make sure that you check your spam box, or some Gmail accounts have like a promotion box. You can check it there. Also, I will be dropping a link to the recording. We are streaming everything on YouTube. You can go to Weber Immigration on YouTube. I will put a link in the chat and you can catch the recording there. Yeah, and let's talk a little bit about what we're going to talk about today. Let's go to our agenda here. All right. Okay, so we're at the day 2 of our immigration summit. So midday, it's going to be fun. So yesterday, let's actually talk a little bit about yesterday. So if you missed it, oops. If you missed it yesterday, so yesterday we talked about express entry. So this is what you learned yesterday. Again, if you didn't catch it, go to Weber Immigration on YouTube. I'm going to drop a link in the chat. You probably received email from us. If you didn't, check your spam box. And if you want to learn more about express entry, everything about, what to expect from express entry in 2026, 2027, common mistakes, express entry for doctors and healthcare professionals, knock codes, how to boost your points. We talked all about there. So go watch the recording, and yeah, if you have any questions, you can always reach out to the speakers or to myself. Now, today, day 2, what we're going to be talking about is about spousal sponsorship. So we're going to kick off with basics. So Sana here is going to talk about eligibility for spousal sponsorship. Now, we do have a lot of questions about Quebec spousal sponsorship. So we're going to welcome Virginia afterwards, and we'll talk about Quebec sponsorship, because as usual in Quebec, things are fun and things are not the same as in the rest of Canada. So those are in Quebec definitely will be able to benefit from this session. We'll welcome Cosima talking about relationships, proof of relationships, and why relationships get refused, and what IRCC looks for in terms of 5 red flags for your relationships. Arsheen will talk about misconceptions of inland versus outland spousal sponsorship, which is super important. And then Carolyn will talk about conjugal sponsorship, which is super interesting topic, because conjugal sponsorship is actually sponsorship for those who are neither married or common law, who are in a relationship, but they live apart, and there's some force between them. So basically, they're boyfriend and girlfriend, essentially living apart usually. And then there's something out there that doesn't allow them to live together, to be married, or to be in common law relationship. So it's very, very interesting topic, which we will close with today. So yeah, that's what you should expect today. As usual, we're going to answer your questions at the end of each presentation, but also at the end of the whole day. We're going to answer your questions. Stick around if you have any questions. We are always trying to answer as many as possible. And yeah, and try to stick around for the whole day if you're working remotely, or if you're maybe in a different time zone, and if you're like cooking dinner, just put it on the background, put it on your TV, and I'm sure that you will benefit from this greatly. So let's start this party. So let's welcome Sana as our first speaker, our first panelist, to talk about sponsorship and talk about eligibility for spousal sponsorship. Hi, Sana. How are you doing?
Hi, Olena. Thank you. Hi, everyone. Thank you for joining. So I see that we have a lot of people joining in from many different places. Okay, so before we begin, please share in the comments which stage of the spousal sponsorship process are you in? So I've listed here. Let me see. Can I send this? There. So are you already married and soon starting the sponsorship process? Or are you midway through compiling your application just before submission? Or maybe you already submitted your application and are waiting for a decision. Or you're not married yet, but you're just gathering information.
So Sana dropped those options in the chat. Just joining from Nigeria. Great. You can comment 1, 2, 3, or 4. So 1, married and ready to sponsor. 2, kind of middle of application. 3, already submitted an application. And 4, not married yet, just like learning, just gathering information about spousal sponsorship.
Great, perfect. Okay, so we have a lot of people just gathering information. So hopefully this session will be very helpful. Okay, so at the end of the session, I have 2 special offers, a giveaway and a promo. So I hope you pay close attention to be eligible for those. Okay, so we will begin now. Let me share my screen.
Yeah, I can see that, yeah, there is a good mix of people. We have married, we have 4, we have 1. Still waiting to find a girlfriend.
Okay.
Just gathering information. All right. Yeah,
And
we're all good. We can see a screen.
senators mode. Okay.
All good.
Perfect. Okay. All right. So today I will be talking about eligibility for spousal sponsorship and how to overcome ineligibility. Okay. So a little about me and how my journey to immigration began. I'm originally from Hyderabad, India. Then I moved to the United States with my family when I was very young. We lived there for a few years and then finally made Canada our home. So I experienced immigration as a child. I've been licensed for over 4 years now, but my journey to immigration began long before that, when I sponsored my husband many years ago. Back then, it was paper applications, and it took me 4.5 months to get an approval and for him to be in Canada. It was about within 6 months, he was here with me in Canada. After that, a lot of my close family and friends started asking me about the sponsorship process, and that's what led me to get my license. Currently, I'm specializing in study permits, spousal sponsorship, express entry, and super visa. Okay. So for any type of permanent residence application program, before you even download the document checklist, you must make sure that you are eligible to apply under that program. Whether that's express entry, provincial nominee program, spousal sponsorship, or any other PR pathway. In a spousal sponsorship, unlike other programs, the eligibility must be met in 2 places. The 2 types of eligibility that I will be covering today are eligibility for sponsor, who is the Canadian or permanent resident spouse in Canada, and eligibility for the sponsored person, who is the foreign national spouse. Okay, so for a sponsor to be eligible, they must be 18 years or older to make an application to IRCC. This is not the same, or it should not be confused with the legal age to marry. This can be different in different countries. So make sure you check the country's law where the marriage took place. The sponsor must be Canadian citizen, a permanent resident in Canada as an Indian under the Canadian Indian Act, or a permanent resident. You must be living in Canada. So if you are a Canadian citizen living outside Canada, you must submit proof with your application that you will resettle in Canada when your spouse becomes a permanent resident. And if you are a permanent resident yourself living outside Canada, you're not eligible to sponsor. You must be in Canada. Okay, and you must be able to support the sponsored person financially. Although there are no strict financial requirements for spousal sponsorship, unless you are sponsoring a spouse who has a dependent child and that dependent child has a dependent child of their own, you must still be able to show that you can take care of their basic needs, like food, clothing, dental, and eye care, and things like that. For a spouse, it's 3 years. For a child, it's 10 years, or when they turn 25, whichever comes first, or 3 years if the child is older than 22 years old at the time they become a permanent resident. This is called the undertaking period. The eligibility part is pretty straightforward. It's the ineligibility that gets people. Okay, so for a spousal sponsorship, it's not okay just to be eligible, but you must also not become ineligible. In a spousal sponsorship, there are two separate lists. The good part is that there are ways to overcome ineligibility. And I will go through the list of what makes a sponsor ineligible and how to overcome ineligibility. The first one on the list is you previously sponsored a spouse or partner, and it hasn't been 3 years since they became a permanent resident. What this means is that you sponsored a spouse or partner and for whatever reason, your relationship shortly ended after they became a permanent resident, and you are now divorced or legally separated. You cannot sponsor your current spouse or partner until 3 years have passed since they became a permanent resident. Why? Because you are still financially responsible for them. The undertaking period hasn't finished. To overcome this, it's simple. You just have to wait the 3 years before you can sponsor your current spouse or partner. The second on the list is your previous spouse sponsored you. And again, for whatever reason, the relationship breaks down. And it hasn't been 5 years since you became a permanent resident. You can sponsor your current spouse or partner until 5 years have passed. This was implemented to circumvent fraud. So there's no chain of sponsorship, or in other words, so people don't use this as a backdoor to immigrate to Canada. And to overcome this, you need to wait 5 years since the time you became a permanent resident. Okay. If you previously sponsored someone, it could be a previous spouse, a child, a parent, or maybe you co-signed a sponsorship with your spouse who was sponsoring a parent. And if they received social assistance from the government during the undertaking period, it means that you have not fulfilled your financial obligation. Hence, you cannot sponsor. So in order to overcome this ineligibility, you must repay the money they received from the government in full. Once you have cleared the debt, then you can sponsor again. Okay. If you are currently receiving social assistance yourself for reasons other than disability, you can sponsor your spouse or partner during this time. Why? Because it shows that if you can't financially support yourself, you won't be able to support the person you're sponsoring. To overcome, you have to come off of social assistance at the time you are sponsoring and throughout the processing to become eligible again. Okay, now this one, if you have defaulted on an immigration loan or a performance bond, you cannot sponsor. This is not a common scenario for many people. It usually involves resettled refugees. It's when you take a loan from IRCC or CBSA to cover your pre-arrival expenses like flight tickets, medical exams, initial settlement, or to pay for the right of permanent residence fee at the time you became a permanent resident. Or you agreed to pay money in exchange for a guarantee that a detained immigrant would fulfill their obligation under the act if they're released. So it's literally a loan from Immigration Canada. This is not the same as having a credit card loan or a student loan or any other types of loans. And it doesn't even apply to situations where you owe money to the CRA, which is a government body. It's strictly to do with IRCC and CBSA. Any other type of loan may affect your credit rating, but your credit rating doesn't affect your immigration file. So to overcome this, you need to pay back to IRCC or the CBSA in full before you can sponsor. And number 6, if you are in default of court-ordered family support payments, such as alimony or child support, you are not eligible to sponsor because it shows your financial incapacity. So to overcome, you must first resolve the payment issues for family support payments before you can sponsor your spouse or partner. Okay, and this is the last set of ineligibilities. If you declared bankruptcy and have not been discharged from it, this can prevent you from sponsorship. I'd like everyone to understand that bankruptcy is a legal process. Just because you have a loan and are behind on payments, and perhaps you've been sent to the collection agency for default payments, doesn't mean that you've declared bankruptcy. However, if a loan or a tax debt has led you to file for bankruptcy, then you become ineligible. Similarly, having a consumer proposal doesn't disqualify you from sponsorship altogether, as long as you are making the payments that you're supposed to. So if you have filed for bankruptcy, it's not the end of the world for immigration purposes. There are ways to overcome it. You must first be discharged from it to be eligible to sponsor again. This also involves a legal process. So once you are discharged from it, you will be eligible to sponsor. Okay, so the next one, if you are number 8, if you are convicted of a violent crime, an offense against a relative, causing bodily harm, or a sexual offense within or outside Canada, this can bar you from sponsorship. These actions have a heavier consequences on the sponsor's ineligibility. The sponsor is considered inadmissible until the criminality section of the act is and is barred from sponsorship. So to overcome this, in most cases, you can apply for rehabilitation or record suspension depending on the seriousness of the violation. It could either be 5 years or 10 years since you completed the sentence or committed the offense. So the only way to overcome this is to wait until you can apply for record suspension, which can be a really long time. And lastly, if the sponsor, who is a permanent resident, has been ordered to leave the country, they won't be able to sponsor. This could be if the sponsor's PR status is being revoked because IRCC has found them inadmissible. And that could be for any reason, like not meeting residency requirements or a criminal inadmissibility. To overcome this, you must wait until you resolve this matter with IRCC. Until then, your application will be suspended. Now comes the sponsored person's eligibility. So the sponsored person is also known as the principal applicant in the application. They must be 18 years or older to make an application, again, different from the legal age of marriage. They must be legally married to you or in a common law relationship. And I'll go into details shortly. They must be in a genuine relationship with you, which means that the onus to prove that the relationship is genuine is on them, not the sponsor. And they must be considered a member of the family class or in Canada class. Lastly, they must not be inadmissible. They must pass the medical, criminal background checks, and that's usually when they give the medical exam, biometrics, and police clearance. All right, so this is how the foreign national spouse can become ineligible to be sponsored by their Canadian or permanent resident spouse. They must show that the marriage is valid for immigration purposes. This means that it must be legally performed in Canada, or if it was outside, it must be legally recognized in the country it took place and in Canada. So make sure you check the local marriage laws of wherever you are getting married. For example, proxy marriages, it's not recognized in Canada. Both couples have to be physically present at their wedding for it to be recognized. Or embassy marriages. These are also not recognized in Canada and also in many other countries. Another reason that can make marriage invalid is when either the sponsor or the foreign national is married to someone else at the time they are married to each other. So a common scenario for this is when at the time of marriage, the divorce is not finalized with your previous spouse. You must wait until your divorce is finalized to be legally married to your current spouse. Okay, and lastly, if you're if you're being sponsored as a spouse, but you or the sponsor are currently in a common law relationship with someone else, again, you're not eligible. This is bigamy and it is illegal. The only time when you can sponsor while you are being married or while you're still married to your previous spouse is if you have lived together with your current partner for 12 consecutive months, then you can sponsor as common law partners. But for this, you need to show strong evidence that your previous relationship is dissolved. So what is common law relationship? It's when you have lived with your partner for 12 consecutive months without any long periods apart, but you are not married to them, but this relationship is still legally recognized in Canada. Okay, but remember, you are not considered in a relationship until the 13th month has started. So if you are living with someone and it's 11th month, you cannot say that you are in a common law relationship because the rule is living together consecutively for 12 consecutive months. And only then, the 13th month, that's when you become a common law partner. So your relationship obviously must be genuine. To assess this, the officer looks at Section 4 of the regulation and they apply the bad faith test. Okay, so what is the bad faith test? It's a legal criteria that officers apply to check two things. Was the relationship entered into primarily for immigration purposes? And is the relationship genuine? Both must be satisfied, and it is not okay to show that your relationship meets just one of these conditions. So, for example, your relationship is probably genuine, you love your spouse, and you want to spend the rest of your life with them. But perhaps the original intention was to gain status in Canada. This will make your sponsorship invalid or your relationship invalid for immigration purposes. Officers are well trained to assess these type of scenarios. They may look at your past immigration attempts or your current status in Canada and how quickly your relationship evolved without proper explanation. So documentation is very important, and the officers must look at the whole picture before failing you on this test. Okay. So the spouse or partner must be member of the family class or in Canada class. These two types of classes will be later covered by Arsheen, another spousal sponsorship expert. Now, what does this mean? They're your spouse, so they're your family, right? But for immigration purposes, you also have to meet another definition. When the sponsor becomes a permanent resident through an economic pathway, such as like express entry or PNP, they are required to declare their spouse or partner, or actually all family members, their dependent family members, such as their spouse, partner, children, and get them examined. which means submitting a medical and a police clearance for them if the child is over 18, before the sponsor becomes a landed immigrant. If this was not done, their spouse or partner has now fallen out of the definition of family class or in Canada class, and therefore they are non-sponsorable. So this not only bars the sponsor from sponsoring their family member, but their own PR application can be revoked for misrepresentation. Right? So this requirement has a heavy consequence on both the sponsor and their current sponsorship and also their permanent resident permanent resident status. So my last words of wisdom are, it is very important to remember that eligibility is not something to be met at the time you make an application to IRCC, but you must continue to meet the eligibility throughout the application processing and until a final decision is made. If officers find that you are not meeting eligibility at any point during the processing, they will issue a procedural fairness letter, and this can seriously derail your entire application or even lead to a refusal if you don't answer the PFL properly. And I can give you an example. So say you're a permanent resident at the time you make an application. You're living in Canada and you submit the application, so you're eligible. But later you decide to visit your spouse abroad for an extended period of time while the application is being processed. And the officer has record of your exit and entries. So if the officer has a reasonable doubt to believe that you are no longer living in Canada, the officer will find that you are no longer meeting eligibility. And they may send you a PFL to prove otherwise. If you can't satisfy the officer's concerns, the application will be refused. So again, it is not only at the time you submit the application, but you must continue to meet eligibility throughout the application processing and until a decision is made. Okay, so that concludes my presentation. And thank you for listening, and do stick around because there's so much more coming in the next sessions with the other immigration consultants. And like I mentioned, I have 2 offers to give to the audience. One is a free consultation for spousal sponsorship, and the conditions are that you must follow me on TikTok. And the second is comment on today's video on my TikTok, the post that I made today this morning. Tell me what you found most useful from my presentation today. And the second offer is for everyone. I will be offering 20% off of all types of consultations till the end of June. All right.
Thank you so much, Sana. That was great. All right, guys. So I'm going to drop a link in the chat for number 1, Sana's TikTok, and number 2 is the link to other resources that she mentioned, how you can contact her. Okay, here it is. I'm dropping it right now in the chat. And all right. Okay, so we have a couple of questions for you, Sana. So if you can go to Q&A box, I noticed there was a pretty good question. I'm not sure if you want to take it from Ola.
So I'm just trying to find the Q&A. I don't know.
Maybe we can do.
Oh, so that's that's the chat, right? And then I have to go to the Q&A.
Do you have the Q&A? Okay, let me just.
Oh, okay. I think. Okay. So sorry, which one?
So from Ola, so if I get to Canada as a permanent resident, having a girlfriend, but we're not married, and she's not a common law partner, Once I get to Canada as a permanent resident, is it possible for me to travel back home to get married and then come back to Canada and sponsor her? How long should I stay in Canada before I come back to get married and then ask for spousal sponsorship, like to sponsor the spouse?
So his girlfriend is in Canada?
Yeah, so I'm guessing is that this person is recently approved for permanent resident. They're looking to move to Canada as a permanent resident, but the girlfriend is back home. And the question is essentially like how long I need to stay in Canada as a permanent resident, and then he wants to travel back home
Yeah,
to get married and then sponsor her, but they're permanent resident, like not
right.
Canadian citizen. Yeah.
Okay. Yes, actually, the moment you land here, you've claimed your permanent resident status. After that, you can leave the next day, get married, and come back again to sponsor your spouse at that time. So there's no requirement that you must stay in Canada as a permanent resident for a certain number of time. As long as you've claimed your status, go back, get married, and come back again and sponsor them.
Sounds good. Yeah, the only one thing, not sure if you kind of implied that, but is that if you are permanent resident, like you have to kind of live in Canada in
Yes,
order
stay in
to
Canada.
sponsor your spouse. Because if you, for example, like you get married and you stay back home, it's not going to work like that because they will refuse. Because you, as a PR, you have to live in
Yeah.
Canada, like reside in Canada in order to do the spousal sponsorship. So you can go back home to get married, but as Sana
But you have to
mentioned,
come
but
back. Yeah.
you need to come back, yeah,
Yeah. To sponsor.
eventually. Okay, good question about eligibility from Rami. It's in the chat. So if a separation from previous partner occurred, but divorce isn't finalized, does that make the sponsor ineligible to sponsor?
Yes. So if you are not currently in a common law relationship with your current, the person that you want to sponsor, you have to make sure that your previous relationship has ended and the divorce is finalized, because you actually have to attach the divorce certificate with your application to show that it has ended. And then you are eligible to sponsor again. But until then, no, there's no other workaround. You have to get that divorce certificate.
So, in like most of cases that I've seen is that like you can kind of like submit your application, but they will still like IRCC essentially will just hold it until you get the divorce certificate.
If you show
That's
like
what I've
it's
experienced.
in process,
Yeah,
right?
yeah,
The
they will
divorce, yeah,
just
yeah,
hold. Yeah, so like in the end of the day, like you will have to get a divorce
yeah.
certificate. Usually they just like stretch out the processing and whatever, because like in the end of the day, they will want to see divorce certificate. Like they understand all the circumstances around it. Like sometimes the divorce, like it's hard to get finalized because the other party doesn't want to divorce, right? And yeah, but I've seen those cases and it's still possible kind of like to apply, but like the RCC would just still tell you like, give me the divorce certificate, give me the divorce certificate. So Sana, as Sana said, yeah, definitely you need to provide that divorce certificate eventually. Most likely that's what's gonna end up happening. Okay, we have okay, so to the let me just see. Oh no, it's a different person. 1 second. Let's just do one more question. Um, okay, let me just go through some questions. Ooh, that's a good one. Ouch. Okay, so it's in QA, question from Zubar.
Mhm.
So my sponsor withdrew the spousal sponsorship application after 4 months of submission as he entered into another relationship. Can he sponsor the new person? I'm so angry and disappointed.
So, because the sponsorship wasn't approved, it didn't reach a final decision. They are not, they have not been signed under the undertaking period. So they're not obliged, they're not, in charge of taking care of you financially. So yes, they can sponsor the new
Yeah.
spouse now. However, maybe IRCC will now look at their application more strictly because, hey, what happened? You were just sponsoring this person and so quickly that relationship is ended and now you're in a new relationship, right? I mean, if that relationship requires sponsoring. But yes, they can cancel the sponsorship at any time before a final decision has been made, and they're not obligated to financially support you in any way.
Yeah. Yeah, that's a good point that you said, is that like even though that like they technically can sponsor the new person, but obviously like how that would look like in IRCC's eyes, like it would have to be a very strong put together application, like that second one, in order IRCC to be good with it, because ultimately it's just like the red flag, like you're within the like last 6 months you're sponsoring 2 people. Okay, like that's very good point.
Get married in Canada.
Okay, so we will have like, let's take this last question, but we will have like a little bit more presentation about this specific issue, but just a good question from Gaurav here. Do you need the same documents or the same number of documents if you get married in Canada comparing to getting married outside of Canada?
Yeah, that's a good question. So I would say it's not the same documents, and sometimes it may not even be the same number of documents. So if we're talking about like supporting documents, right, like photographs and chat messages and things like that, IRCC does provide a document checklist where they give you options that if you're living together, these are the type of documents you must submit. And if you're not living together, then you must submit this. So naturally, you will have different set of documents to provide in each type of scenario. Like I always tell my clients, for example, if they are living together, then they will have documents like, lease agreement, or maybe they named each other in the insurance and things like that. And if you're living apart, you will probably have more documents surrounding like chat messages, phone calls, and things like that, because you're not going to be chatting so much with the person that you're living with, right? But if it's long distance, you're going to be calling them more, so you can show proof that here's my call logs. So they're different set of documents, but they both involved. They do both involve a large document checklist for the sponsorship process.
Yeah. Sorry, just a last question, just because I wondering about this myself. I don't remember from top of my head the rule about it. Can you explain a little bit to Lucy here the rules around bankruptcy? So if the bankruptcy is completed, like now, like how does it work? Like, is there a time period after which person filed for bankruptcy that they cannot sponsor another person? Or like what's the deal with bankruptcy in terms of sponsors eligibility? I don't remember this from top of my head. As you guys can imagine, it doesn't come across too often.
Yeah,
and we've had actually one case in our 10 years of practice that involved bankruptcy.
Yeah, so as long as you've been discharged from the bankruptcy, and I know like it's something just like after 9 months, or there's a certain period and you must fulfill the conditions. Once that's done, you are eligible to sponsor again. There's no waiting period. You just need to show or be clear from it. So as long as that's been done, taken care of, you can sponsor again. The thing is, the moment you have satisfied your non-eligibility, you become eligible, you can sponsor. There's no waiting period after becoming eligible that you can sponsor.
Yeah,
That
makes sense.
Yeah.
All right, Sana, last thing about you. Can you please remind people your consultation giveaway? What are the conditions? I just put the link in the chat to your TikTok. So how do they enter into the giveaway?
Okay, so the one of them, you can have a free consultation. You need to follow me on TikTok. And this morning, I posted a video. So go to that video and just comment one thing that you found useful from my presentation. And the second giveaway is you have 20% off of all consultations till the end of June. And the promo code is Summit 2026.
Okay, promo code Summit 2026. If you have any issues, guys, with any of that, or you didn't catch something, recording of the session is on our YouTube. Gonna drop a link. I know Charles was asking about it, so I'm gonna drop a link in a second. It's right here, and then you are more than welcome to reach out to myself or to any of the speakers on any social media, because we're all available. You can DM us and we will help you out. Okay, Sana, thank you so much. It was great. And we're going to move on to our next topic. And the next topic we have about Quebec and sponsorship in Quebec.
Okay, thank you, Elena. See you, everyone. Bye.
Thank you. Okay, we have Virginia Melo here, and Virginia is licensed to practice in Quebec. She is only one out of all the RCIC's immigration consultants here who are licensed to practice in Quebec. And Quebec is a very much different cup of tea, always different, always fun. So we get a lot of questions about Quebec spousal sponsorship. It's not easy. It's has its own things to navigate. So we always direct everyone to Virginia because she's the expert here. All right, Virginia. So tell me, welcome, number one, and tell us what you have prepared for us today. Oh, you muted.
Yeah.
Perfect.
Better?
Yeah.
Hi, everyone. Thank you for having me. Thank you for the opportunity. Yeah, Quebec, la belle Provence. So what happens, just give you guys some information about myself. So I'm in Canada since 2009. I came for a 6-month period and never left. So this is the Canada effect on us. I lived in Quebec for 9 years and a half, then I moved to Toronto, and now I'm in Calgary. So I've been trying many different scenarios in Canada. I'm licensed in Quebec, and Quebec is a special province. So we are going to to dissect a little bit the situation. It's how can I say? It's not that it's easier than the normal spousal sponsorship, but there's a little trick that we are going to cover. Can I start sharing my screen?
Yeah, you can start sharing your presentation. While you doing that, just a reminder for everyone that we will be hosting a Q&A session at the end of the day today. So bring your questions. We have RCICs joining us, additional RCICs joining us. Bring all of your questions end of the day, and we will be sharing those with sharing our answers with you. All right, I can see your screen.
Can you
Okay,
see?
yeah, everything looks perfect. Continue to share. Yep, everything looks great.
Okay, so I think I move. So we are going to lay down the specificity of Quebec. Quebec happens in 2 stages. You have the IRCC stage that will cover everything that Sana beautifully explained before. So the eligibility criteria for the sponsor, the eligibility criteria for the applicant, so the medical, the criminal record, the relationship, if it's real or not. And the difference in Quebec is that when we talk about undertaking, the undertaking goes to the MIFI, that is the Ministère de l'Immigration, Francisation et l'Intégration, Inclusion, sorry. So they will define if you are eligible to sponsor someone in the financial part of the process, okay? As I said, the eligibility criteria is going to be basically the same. IRCC will check all the points, see if you are not eligible, like Sana mentioned, with bankruptcy, how do you say? Forgot the word. Criminality, on all those things. But then we are going to go back to Quebec. So what is going to happen is you submit your application for the IRCC with all the information, all the documents. IRCC will check if the sponsor is eligible for your application. And then they will send you a document, a letter saying, okay, you passed the sponsor eligibility. So now you can go to Quebec and tell MIFI that you are at the stage of the undertaking. So MIFI will get the information about your financial situation. We are talking about sponsor. Quebec will not check the applicant spouse, the applicant, that is the spouse, sponsored spouse. So they will check the sponsor situation. And what does it mean? The undertaking is a legal commitment by the sponsor. They will say to Quebec, say, I'm responsible economically for this person. I will cover all the basic needs like housing, clothing, food, and some medical expenses that is not covered by the medical, the public medical, the health system. Sorry. And I'll do everything. I'm also responsible as a spouse to help the sponsor, the spouse, to integrate in Quebec. So it means how to learn French, even if it's not required for the application that you prove that you have French, you will have to assist your spouse to integrate and learn the values of Quebec and learning the language of Quebec.
Virginia, sorry to interrupt you. I just
Sure.
want to make sure that you can change the slides because the slide is still the first one that I see.
Oh, on my screen it's changing.
And I just only now realized that that's probably not supposed to be like that.
Hold on, let I stop sharing.
Yeah, maybe we can fix this
Okay.
up or
Share.
try to.
Okay, because on my end it was moving.
It's very strange
Sorry.
that this time around we've had Zoom. Yeah, we've had Zoom very finicky.
Now can you see it
But
changing?
yeah, you have to share again. I don't see your screen.
No. Oh,
No.
it shows that it's sharing.
Yeah, tag like so this time around we've had this is our third immigration summit, and this time around it feels like there are more technical problems, and I want to say that it's Zoom's fault.
Sometimes they how can you say they create so many options
Yeah.
and let's see if it
Okay, now it starts sharing again. So if you want, you can honestly just leave it like that. We can perfectly see everything.
Can you see?
Yeah, I can see everything, and then you can change the slides like that. Yeah.
Okay.
Yeah, that would be the best.
Okay. So I think I was here. So as I was saying, the undertaking is the legal commitment, and the Quebec will see if you are you can support your spouse when you are in Canada, when they arrive in Canada. As the federal sponsorship application, the undertaking for a spouse is 3 years. If you have a child, then you have the 10 years undertaking duration, but for spouse is 3 years. And it starts when the spouse the sponsored person becomes a permanent resident, and you cannot stop it once it started. Okay, so oh, I got divorced after 1 year. Am I responsible for this person? Yes, until the end of. Oh, I lost my job. Am I responsible? Yes, you are responsible. That means anytime the sponsored person uses some benefits from Quebec, it not all benefits, but some support, some assistance, you have to pay back Quebec this ad, okay? So it's during all the period of the undertaking, so you don't have an option, okay? So what can block an undertaking approval? Not every government benefit is the same. So you can have employment insurance, it's okay. You can have the child benefit that in Quebec is very good. It's okay. You don't have a problem with that. Or if you have student loans or bursaries, it's okay. But if the assistance you have from the government is for the last resource, it's considered a last resource financial assistance, yes, this is a problem. That means you cannot support yourself. How can you support someone else? So they will see if you have those ads usually cover for housing, for food, for clothing, and this is what is considered a financial last resource financial assistance. This can make the sponsor ineligible to give the undertaking. So this is very important because sometimes people understand like, oh, I have an employment insurance that I'm at the moment. Is this considered? No, because first, EI, it's a federal assistance and it's an insurance that was built up from your previous work. It's not something that the government is giving you from taxpayers, okay? So this is the important. Intake issues. In 2024, Quebec decided that they had reached the quota for the sponsorship applications. So they stopped and they paused all undertaking applications for spouse, common law, and conjugal partners. This created a really mess because people that were doing with an application running with IRCC could not continue because they were not receiving any application. And the pause was for 2 years. So they stopped in June 26, 2024, and they are supposed to return on June 25th, 26. So we have a backlog of applications for 2 years. Everybody that was a sponsor, that lives in Quebec and was a sponsor, a family member, got stuck. So this will return if nothing changes, because sometimes politicians decide to change things from one night and day. So we are resuming the applications on the 26th. We don't know how long it's gonna take. We don't know how the application must be submitted yet. If it's like in 2024, the Quebec undertaking application is a paper-based application. So you have to gather all the documents, print out the forms, sign physically. They usually don't accept electronic signature. Put everything in an envelope and send it to Quebec. So this is, if it continues, if nothing changes until June 26, that's how you submit your application for Quebec. And processing time. Quebec is usually, the processing time for sponsorship application is usually longer than the federal one. Before, in June 24, the processing time was, for the federal part of the application, it was between 24 to 30 months of the application. The MIFI, the Quebec part was not a problem because this was usually like 3 to 4 months, the deadline for the application. The problem was the federal. There is no official information or reason why it takes that long. Since the application is basically the same, you just have one portion of the application that's used, that is processed by another government. But my perception is that, okay, you stop the application, and when Quebec gives the okay, your applications went to the end of the line. This is my perception. So today, if you go to the website, the processing time is about 35 months, but we don't know because it's closed. So we will only have an idea what's gonna be after Quebec reopens and start receiving again the undertaking application. And so what does it have? How does it happen? They will evaluate, they will see, okay, I'm good, you are a good candidate, I approve your undertaking. Quebec will send, again, it's a paper application. They will send you the letter of confirmation of your undertaking, a copy of your application, and the CSQ. The CSQ is the Certificat de Sélection du Québec. This is the document that the sponsor must give to the spouse, so they will continue the application. Will Quebec MIFI send this information to IRCC? Yes, they will transfer all the information for IRCC. And once Quebec gave the okay for the application, IRCC will continue the processing of the sponsorship. At this phase, IRCC will see if the relationship is real and the admissibility of the applicant. So if they have medical issues, if they have safety, security, criminal issues, this is when it happens, after the undertaking. Usually what people ask when in a consultation about sponsorship application, what do I apply first, Quebec or IRCC? You first apply IRCC, and only after IRCC gave you the okay, saying that you passed the eligibility for a sponsor, you can submit your application for the undertaking with Quebec. The CSQ are going to be the same application for the undertaking. So you send all the documents with the undertaking, and when they approve the undertaking, they will issue the CSQ. The payment for this process, it's a form that you fill out with a credit card, and the credit card is charged by MIFI. Another question usually asked, do you have a document, something that prove that MIFI received my application and is processing my application? No, you don't have an official document. What we usually follow is the tracking document. So always, always, always submit your application using a tracking system. the credit card charge. So you know that your application is being processed when they charge start being processed is when they charge the application fee on your credit card. And then they will send you an envelope with all the papers confirming that your application was approved, or if it's the case, returned. Another question is, can the sponsored spouse work while waiting? If in Canada, yes, it's the same process as the federal sponsorship application. That means if you receive the confirmation of receipt of your application, you can submit the work permit being in Canada. We talked about the processing time. Another question that always appears on the consultations is that, okay, if Quebec takes so long, can I move from Quebec and do my application from outside? The point is, if your intention is leaving Quebec, no. Because if you do this move just to get the sponsor, the PR for your spouse and then go back, this is gonna sound like a misrepresentation. So your intention is not live outside Quebec. You can do, if you can prove that your intention is really, really be outside Quebec. So that's not a problem. Another problem is that everything in Quebec, you have access through your CSQ. So you need to get your REMQ. It's the carte d'assurance maladie, the health card. You need your CSQ to prove that you are a Quebec resident. You want a scholarship or some funds for going back to school, the school will ask for your CSQ. So it's not that you can say, the government will not see or will not understand and not. But when you get in Quebec, everything is going to be complicated. Okay, so no, if your intention is leaving Quebec, do the right thing from the beginning. Another thing is important to know is the French language. As I said before, although it's not required to pass a test language, the new bill for the French language in Quebec is very strict. There are some services that you cannot have service if you don't speak French and you are in Quebec for more than 6 months. So when your spouse arrives in Quebec and got the PR, it's the responsibility of the sponsor to help them to get the help to learn French. Quebec has a lot of options. They have assistance, they have the classes that you can apply and you can take language class for free. They have financial assistance for that, so you can go learn French, but it's very important. There are some services that you cannot get if you don't have any French language. It's hard to live. Montreal, you can survive, but outside Montreal is impossible. So before I apply to Quebec, make sure that you intend to live in Quebec. If you are eligible as a sponsor, if your spouse is eligible, like admissible to Canada, check if you have all the financial situation, although you don't need, there's not a specific amount that you have to prove, but you have to prove that you can support your spouse. Remember that the undertaking is for 3 years and it's your responsibility, and you will, there's no way for you to get rid of these 3 years. check if you are doing inland or outland strategy. This we are having someone, I think Arsheen is going to talk in details about the difference of inland and outland application. If you are inland, if you are looking for the work permit, check the conditions to apply for the work permit. And this is the Quebec. It's not so complicated, but you are dealing with a different government institution. And to deal with MIFI, you must speak French. If you call them and you don't speak French, they will not help you and they will not assist you. So I will take questions now. This is my information. So if there's something that is not answered today, and if you need more information, you can contact me through Instagram. There's my consultation information. So if you need help, I'll be available. And we'll be giving 15% on the consultations until June 15. And the code is Summit 2026. So if you want to start your application or just want to see where you stand with the Quebec, please, I'll be available. So
Okay, thank you so much, Virginia. It's really good. Okay, guys, if you have any questions, drop them in Q&A box or chat. I see one question here
I'll
from
stop sharing because I cannot see the questions.
Yeah, you can stop sharing, that's fine. I have one question from Pavleen here. So Pavleen is asking, just to understand, inadmissibility is again assessed by Quebec government, even if you are approved by IRCC?
They will check your financial inadmissibility. So they will check if you are using social aid from Quebec, they are not looking the age and the details that IRCC did before, but they will check your financial situation. That's where you can be inadmissible, is for financial reasons.
Yes, for sure. Another question I have that people ask us all the time is that when the sponsor lives in Montreal, for example, which is very common, and they want to sponsor their spouse, they come to understand that they need to go through all of this process that you just explained, and they come to understand that it is crazy and more complicated. What they do is that they always ask a question, is like, what if I move to like Ottawa, which is like an hour from Montreal, and then do my sponsorship and then like go back to Quebec when the sponsorship is done? Or what if I put my address for, my friend in Ottawa and, do it that way? Like, I'm sure you've, through years of experience, you've heard this question before.
Yeah.
What do you usually say to those people?
I think an immigration application must come from a real part. So if you start your process lying this is misrepresentation. So don't do it. If you really intend to live outside Quebec, go to Ottawa and make your life there, it's one point. If you are living in Quebec and submit an application saying that you intend to live outside, you have to prove that you have this intention. Go through like a job search, housing search, and all those things. And as I mentioned before, when you do the application any application through Quebec, you receive your Certificat de Sélection, the CSQ. everything you're going to do in Quebec, you need this to prove that you are a Quebec resident. So sometimes it's more important the CSQ than the PR card. So if you are going to apply for your health card, the HEMQ, they will ask for your CSQ. And if you don't, you have to explain very hard why you just arrived in Canada, in Quebec, and you don't have a CSQ. If you are coming from another province that you lived a few years and you have the other province card, it's one thing. But you just came to Canada in Quebec and you don't have a CSQ, it's hard to get your kids in school.
Wow.
Because they will ask the CSQ. It's hard to get a student loan because they will ask for your CSQ. So it's complicated. And it's not right. It's
Yeah.
just so if this is the case, usually I don't take the application to do. If you start lying on the process, this is something.
Yeah, for sure. Okay, we have another question from Rami. It's in the chat and it's the last question there. If I understood correctly, paper applications will be accepted post June 26, 2026 date, since applying on MIFI is not possible at the moment. Is that correct?
You mean paper application for the RC? MIFI is not accepting anything at this point. They will reopen in June 26. Okay. What is happening is IRCC is still accepting the application for spousal sponsorship. So you can start your application with IRCC, get your approval, and once the MIFI opens on the 26th, you just submit everything with the paper. If it doesn't change, because it's important to understand, Quebec is the immigration system in Quebec changes from night to day. So you went to bed today, everything was fine, and tomorrow the program you are submitting the next day doesn't exist anymore. It happens the last 2 years a lot. So we don't know if they are going to change the rules. We don't know if they are put this application on the system that is called AHIMA. That is the platform they use for submit PR applications. So I cannot answer. For now, yes, you submit your application to IRCC, it's open, they are accepting, not a problem. And once 26 arrives, you submit your paper application for MIFI.
Makes sense. And just to kind of reiterate, I know you don't know, but many people ask, so okay, it opens on 26th of June that you can submit application to MIFI. And so for how long it's going to be open?
We have no idea. Because imagine you have 2 years of a pause on the process. How many people waiting for this? So 2 years is a lot of time.
So the people that have not been able to submit their application to MIFI, they just have been like stuck in this limbo when their application in federal government is in process. Federal government is waiting for Quebec, but you're not able to start the Quebec process because Quebec MIFI is on pause, and that has been for 2 years already.
Yeah.
Wow.
So imagine you submit your application with IRCC in May 2024. So everything was fine, and you are waiting for the confirmation of your sponsor. On the 26th, on 25, 24 of June, they said, okay, we don't receive anything because we reached the limit. So, and you receive your paper the day after. So you've been waiting since June 2024 to finalize submit the undertaking request. So how many people are in this situation? How many people was preparing to apply for spousal sponsorship during those 2 years? And they are
Yeah.
waiting. We don't know. What I'm doing with my clients is everything is prepared, and I have someone. I work with a colleague in Quebec. Then we are sending someone to the line in front of the MIFI office on the 26th with all the packages and say those are the applications we have, because it's
Yeah.
gonna be it's crazy, but that's
Yeah.
the
That's what
reality.
it is. Yeah. Yeah. Okay, just a last note, because I can see the question from Tracy, which is, oh, wait, 1 second.
It's
Yeah, let
based
me
on
just
the
mention this. It's not a spousal sponsorship question, but it is a question that relates to Quebec and to somebody that applies under express entry while like living in Quebec. And just a little note, like we will, Tracy, you can come to our Q&A sessions. We will, like our express entry experts will answer that. But I just want to let everybody know is that Virginia is like literally the only one RCIC here who is licensed in Quebec. So even if not spousal sponsorship, but any other Quebec immigration consultations, any immigration issues, that's all to Virginia. Because the way it works is that normally immigration consultants who don't practice Quebec and who don't have immigration license in Quebec, they really don't know much about Quebec. Like I have no knowledge about how Quebec things work. So anything that you're interested in about Quebec immigration, that's all to Virginia, economic or spousal or whichever case it is.
temporary.
Yeah, now I don't know if you want to address Tracy's question.
Where is in the Q&A or
No,
the
it's in the chat.
Tracy, okay. I applied for PR under express entry, federal skilled work from inside Quebec, and submit and intend to leave. At the time of the application, I did not have a job. However, I just got a job. I still plan to leave though. Do I need to declare this to RC? You mean declare the job? No, you don't have to declare the job now. But it's important to understand that when you get your PR, you are supposed to take your everything and move to another province. It's important to know that lately IRCC had been sending requests to prove that you really intend extra documents, that you really intend to leave Quebec. So I suggest you to start looking for a job, apply for positions outside Quebec, start exchanging emails or communication with companies outside Quebec. So you have something to prove that you are trying to move, to do the move. Another thing is, if your company allow you to work remotely, they can provide you documentation showing this, but all your payment, everything that must be linked to the other province. So tax purpose, for medical, the health card, everything that's gonna be transferred to the other province.
Yeah, makes sense. Okay, and let's take this question from Sandra. It's also in a chat. So
Okay.
in a spousal sponsorship case, the Canadian spouse does not have a passport, but has a birth certificate as proof of Canadian citizenship. And the I guess the sponsored spouse, the applicant, only has an expired passport from Cote d'Ivoire. Will submitting the application without passports basically cause problems?
I would say yes, you need a valid identity document. So you should, the birth certificate works because it's the proof of citizenship. So that's not a problem. But for you, without a valid passport, if you have to apply right away, I suggest apply with the one that is expired, but prove that you are in process of renew your application. Because the moment they approve your application, you will need a valid document to enter Canada. So you don't have an option for the expiration, the expired passport.
Yeah, so it's important to note here is that, like, as Virginia said, is that you can apply, which is very different for spousal sponsorship, because I think spousal sponsorship is one of not many application types that actually will allow you to apply with expired passport. So they will accept the application, they will not return it, they will accept it, but they will request your valid passport when time comes. Now, for other application types, especially economic immigration, like express entry or anything like that, like PNPs, you just can't apply with expired passport. It's just, it will never be accepted. They will never, start considering it unless it's a super crazy exception. But for spousal sponsorship, like you can apply, but like you need to actually get the valid passport at some point.
And just remember that all those things are points that will delay your application.
Yes.
So it means, okay, you don't have the passport, so I have to request a passport. So I will stop everything and your application goes to the end of the line. And I don't know when I will go back to the processing of this application. So your passport is expired, go ahead and renew it right away. So it's an important document.
Yeah, for sure. All right. Well, thank you so much, Virginia. It was really great. Once again, you can find Virginia's information in the chat. I dropped it in chat a couple of times. Also, just a reminder for everyone that you can always watch the recording of the sessions I know it's a lot of information, so if you ever want to like revisit it, you can always watch recordings here on YouTube. I'm just gonna drop the link here, and it will be all the recordings of the days there. You will receive an email with all the speakers' information. Also, under YouTube video, you can find information of all the speakers, their contact details, their booking links, websites. If there's anything that you need, you always can comment under those videos, and I will be happy to, to provide you what you need in terms of the contact details or anything like that. And you can contact our speakers as well on their social media. So we're ready to transition to our next speaker. Before that, just want to quickly share our agenda for the day, since we are approaching midpoint of our day. So let's just go here quickly and let's see what we already have listened to and what is still ahead. So we already went through Sana's presentation about eligibility for spousal sponsorship. Things are straightforward there, but sometimes it's not that straightforward. Sometimes there are things about, bankruptcy or age or anything like that come up, or previous relationships. So we had some good questions there. We listened to Virginia about Quebec sponsorship. Again, Virginia is only one our Quebec licensed consultant here during this summit. So all the Quebec questions, please direct to her, because I know nothing about it. And then right now we're going to welcome Cosima McDonald. And Cosima is going to actually dig deeper into the relationships and how to essentially prove your relationship for spousal sponsorship. So that's kind of like your meat of spousal sponsorship application, I would say. So to the point right now is that we've been like covering a little bit more surface level or like basics or foundational stuff about spousal sponsorship. Now we're going to really get into more nitty-gritty of spousal sponsorship. So Cosima will talk about relationships and basically 5 red flags that IRCC is looking for when it comes to relationships. After Cosima, we'll have Arsheen talking about inland versus outland spousal sponsorship. Super common, topic and questions that we get all the time because it gets confusing, especially as, like we travel back and forth between the countries that we came from and Canada. And, it can get like pretty blurry lines when we're filing for spousal sponsorship. So inland versus outland, the decision to make which spousal sponsorship you're applying for, inland versus outland, is super important. And the last presentation, we're going to have Carolyn Watson talking about the spicy and a little bit, I would even say, controversial topic of conjugal sponsorship. So conjugal sponsorship is basically a sponsorship between, so to speak, boyfriend and girlfriend, and that can be a very, very gray area in many ways. So once again, like very interesting presentation, and about 2:45 Eastern. So about just 2 hours from now, we're going to have our Q&A session. So we're going to welcome all our speakers to our Q&A session. So you will be able to ask them questions about spousal sponsorship, or maybe even other topics if they will be taking questions on other topics. So make sure you join 2:45-ish Eastern. And yeah, so we are, if Cosima is ready to start, we are ready to welcome her. Hi, Cosima, how's it going?
Hi, good afternoon, good morning. How are you?
Good. Okay, we are all ready for
Awesome.
fun to begin.
Oh yeah, thank you so much, first of all, Elena, for having me today. I am super excited to be among such great peers and in front of you. Everyone today, fingers crossed, technology is going to be on my side. Yeah. So I will start by trying to properly share my screen.
Yeah, no problem. Okay, I can see some very interesting questions already here. So just remember, guys, that after presentation, Cosima will be taking questions, and then at 2:45 Eastern as well, she'll be taking questions. Okay, yeah, Cosima, we can see your presentation, so everything's good.
Awesome, thank you so much. So good morning, good afternoon, everyone. We're moving from Quebec to the beautiful blue water city of Sarnia, Ontario. My name is Cosima McDonald. I'm a regulated Canadian immigration consultant, and I specialize, among others, in spousal and partner sponsorship, specifically the complicated ones, the ones that other people typically, hand back and say, just good luck with that. Now, today we're going to be talking about why good relationships run into trouble. And I promise you, by the end of this, you'll never look at a spousal file the same way again. So grab your coffee, and this is going to be fun. Typically, a spousal sponsorship file, it is so different from everything else. It is a more delicate approach. It's not very straightforward. The eligibility is pretty clear in terms of who can sponsor, who can be sponsored. But when we get into the realm of the actual relationship and the proof of being genuine, that's where all the tricky parts start happening. Because, right, how do you actually translate a feeling into something that advocates for you? And this is the biggest challenge. Now, let me start with something I hear constantly. A client comes to me, sometimes after a refusal, sometimes before, and they say some version of, but we're genuinely in love. There's nothing to worry about it, right? And every single time I have to deliver the same uncomfortable truth. Nobody's questioning your love. IRCC isn't sitting there saying, these two don't have feelings for each other. What they're asking is, does the file prove it? A weak file doesn't mean a weak relationship. Please remember that. It means the story didn't come through clearly enough on paper. And here's the good news. This is totally fixable. A bad feeling isn't fixable. A file with gaps, that's exactly what I do. Now, So here's how I want you to think about everything we're covering today. Every document you submit, every photograph, every letter from your mother-in-law who misspelled your name, but well, clearly she loves you, it all passes through one lens, one question, and one filter. That's it, just one. And then when you really understand what that question is not what people assume it is, for sure, it completely changes how you build a file. So let me show you how. Here's the question. Is this a genuine relationship, or is it primarily entered into for immigration purposes? So see, right away, we have two layers of this. The genuineness. Do you guys really get along and love each other and want to be together? Also, are you primarily into this for immigration, right? So that's the question behind every spousal sponsorship file. Full stop, not are they happy, not do they love each other. The question is genuine or transactional. Now, here's what makes this tricky. A file can raise that question and create real scrutiny, even when the answer is obviously yes, it is a genuine relationship. Things such a fast timeline, a thin chat history, no third-party witness, those things look suspicious on paper, even when the couple is completely real. The flag doesn't mean the answer is wrong. It means the file isn't telling the story loudly enough. So that's the gap I really live and work in. To understand where these files get into trouble, I use a framework I developed that is called TRACE. I tried for a long time to translate something vague into something concrete, into a system, into a guide that will prevent me as an immigration advocate for you to miss any gaps, any squeaky parts in a file. So I use a framework I developed that I call it TRACE. There are 5 pillars. Each one maps a dimension of relationship evidence that IRCC actually evaluates. T is for togetherness. Did you actually share a life, or did you just, share an address on paper? Because officers, believe it or not, know the difference. R is for relationship history. Did this relationship grow in a way real relationships grow? Messy, gradual, just human, or does the timeline look more like it was engineered a lot around a deadline? The middle component is A for affirmation. Does anyone on earth really know you're together? Does your relationship have witnesses? Does your family, your friends, anyone around you, right? When you're in love, genuinely, you want to scream it to the world. So affirmation is a very, very important aspect. C is for communication. Can you show you talked consistently over time? Or do you have, 14 curated screenshots and a prayer? Communication, very important. The last component is evolution. Are you building a real shared life together? Does it look like you're just building a file, right? You need to show you see your relationship beyond the PR approval. And here's what matters about TRACE. A file doesn't need to be weak across all 5 to draw serious scrutiny. One thin pillar here is enough to invite questions about the rest. It's like a chain, and officers are very good at finding that weak link. So here are again the 5 red flags. One pillar per one red flag per each pillar, and what they signal to an officer reviewing your file. Togetherness. The red flag, you don't actually know each other. Red flag 2, your relationship history. The timeline looks kind of rushed. Third one, you're the only 2 people who know that you're married or together. The fourth one, communication. The chat history is very thin. And the last, about evolution, the engagement happened, let's say, the week of the principal applicant status in Canada visa expired. So now let's go through each one of them. Now, before we get into the red flag one, I want us to have, first of all, a little fun, and I want you to think a little bit. Now, IRCC, let's say, interviews you and your spouse. Obviously, they do it separately. This is standard practice. The officers ask each of you, what side of the bed does your partner sleep on? One of you says left, the other one says right. What happens next? And I want you, if possible, just for you to type your answers in the chat. And I will try to figure out how I can actually see this properly. Okay. Yep, you are correct, Zubair. The answer is B. Obviously, one mismatch doesn't tank the file on its own. But here, again, what this can do, it tells the officer to keep looking. And once an officer is actively looking for inconsistencies, trust me, they will find them. That's the job. Small things become patterns, patterns become questions, and questions become delays, or worse, a file that needs to be rebuilt from scratch. Now, red flag one, clearly you don't really know each other. It is about togetherness. So on the left side here, there are several examples or instances on what a risky file looks like. So, for example, both partners, when are interviewed separately, they contradict each other on things they absolutely should know. And I'm not talking about obscure trivia here. The basics, daily routines, each other's family members, what they actually do when they come home. The file, for example, if the couple has no lease in both his names and they're both living in Canada, no shared utility bills, no mail going to both of them, just two people saying we live together with absolutely nothing to back it up. Files like that draw scrutiny. Sometimes they still get approved, but they make the officer work for it, and that's never where you want to be. The strong version, on the other side, both partners independently describe each other's lives with almost identical and specific details, which is normal. You know, real documentation of cohabitation, like a lease, utilities, mail, knowledge of each other's families, habits, quirks, pet peeves about each other, right? Like you twist your hair in a way I don't like it, or my partner sucks his teeth or her teeth. Very, very basic, mundane things, the boring stuff. And the boring stuff is the best proof. So as a fix, talk to each other about the boring things. Sit down together, not to rehearse, but because you're genuinely sharing a life, you should be able to describe this, to describe everything the same way without even trying. Now, if you sit down and you realize you cannot really do that, that's a gap worth closing before an officer finds it first. You found it, which is the greatest thing you can do. Love is not the file. Proof of love is the file. That's the whole game. Now, are you ready for another quick quiz? We have this scenario. Couple meets online in January, engaged in March, sponsorship filed in June, completely genuine relationship for real. What do you think would be the officer's first instinct? Anybody? You can type in the chat, A, B, or C. Great answers. It is B. Clearly, every time. Now, remember, IRCC is not The Bachelor. A fast courtship on paper raises questions, even when the relationship is completely real. The solution isn't to apologize for the timeline, but instead is to build around a file so through it answers the scrutiny before the officer even finishes forming the question. Anticipate what they will ask. So this would be the red flag. 2, the relationship history, part of the trace system, where the timeline just looks rushed, right? In the risky version here, we have examples like met and married within a couple of months, nothing is documented in between, the narrative is basically just a list of dates, not more so of a story. So no explanation for why things moved fast, a significant age gap with no evidence of literally genuine shared connection. If there are previous other short marriages or previous sponsorships in their history, there are unaddressed or absent. Now, that file is going to get a long, hard look. On the other side, the strong version is an actual story, messages and photos that show the connection built in real time, not just assembled after the fact for this specific application. Honest context that explains that fast pace. Because sometimes there are genuinely good reasons for a very fast courtship, like cultural norms, circumstances, long distance logistics, and an officer who understands why reads that file completely different. Both partners independently tell the exact same story every time. So what is the fix actually? You know, you can't rewind a calendar, but you can make a fast timeline make complete and obvious sense. A rich narrative plus a dense, genuine message history equals basically an officer who stops squinting at your dates and starts believing your story. And this is the ultimate goal. Another quiz here to make sure that you guys have some input. So spousal sponsorship file, legally married for 3 years, 0 third-party support letters, not even one. What does the officer think in this case? If you can put your answers in the chat, that would be great. Option A, their loved ones are probably just very private people. B, they're probably just forgot to put letters in. Or C, does anyone, literally anyone, know this marriage exists? Awesome. Indeed, the answer is C. Every time. Genuine relationships make noise. People know. They're witnesses. Again, you're in love. You want to scream it to the world from the top of your lungs. You tell your best friends, you tell your parents, you tell your siblings, you tell strangers, right? A marriage or a relationship that exists in complete isolation, no letters, no community, no evidence of a social life together, raises a very specific question. And you don't want that question in that officer's head while they're reading the rest of your file. Now, this is the third red flag, the affirmation. And again, how does a weak file look like? With no support letters or letters, they say, oh, they seem happy and nothing beyond that. I'm sorry, but they seem happy. It's not a support letter. That's something you'd say about a houseplant. No photos at any family events, no sign that either family even knows the relationship exists, or letter writers who just couldn't name a single specific memory if asked. Now, this kind of file has a visibility problem. It's not evidence of fraud, but it's a gap that invites a question. On the other hand, a strong file in the affirmation section has letters that with actual memories, not speeches, but stories. I remember when they first told us for example, is worth more than 10 letters that say, oh, what a lovely couple. Photos at real events, right? Birthdays, family dinners, weddings, wedding after party, you know, late at night when you're just with a couple of friends and everybody took their makeup off and their high heel shoes and you just all huddle around the fire. That is more personal than the main wedding shot where everybody sits pretty for a portrait, right? Everything like this, captioned, dated, identifiable, letters from people across different areas of both of your lives. And when possible, letters from people with standing in their community. For example, spiritual guidance, or your employer, various areas of your life, not just friends and family. So the fix, if you do notice this gap in your file, and almost nobody does this right without being told, brief your letter writers. Do not give templates. Don't get me wrong. Do not give templates, but sit down with them and tell them what's actually useful. One specific story-filled letter from someone who genuinely knows you as a couple is worth more than a stack of generic ones. So this is one of those things that sounds simple, but consistency trips up files that are otherwise pretty solid. It's time for a little quiz again. Now, this is the scenario. 3-year relationship. Great narrative, beautiful photos, communication evidence. We have this. We have 14 handpicked WhatsApp screenshots from the past 60 days. That's it. So what would be your verdict? A, clean pass. B, refusal risk. Or C, officers loved a curated highlight reel. So if you can put in your chat, Zubar says B. Okay, sorry, Zubair, I keep misspelling your name. B. It is a hard B. Now, when a multi-year relationship shows 2 months only of messages, the question isn't, again, are they in love? The question is, when did they start this application? When did their relationship started? The curated highlight reel signals exactly what it sounds like. Real relationships are consistent. They're ongoing and honestly kind of boring in the exactly right ways. So for the fourth red flag, the trace framework, the communication. A risky file would look like this. A handful of beautiful, carefully chosen screenshots with no frequency, no rhythm, and no patterns. No call logs, no video history, no emails for long-distance couples, no phone records, months-long gaps with nothing to explain them. One app, one short window, supposed to represent years that you've been together. I once reviewed a file for a 3-year relationship with 18 WhatsApp messages in the entire package. 18. I genuinely thought pages were missing. So strong communication shows logs with frequency and a rhythm. And I mean the ordinary stuff, not the highlights. Video call logs with dates and durations, phone bills, where this is relevant. For couples navigating the language gap, translated logs with context. Evidence across multiple platforms, a record spanning at least 12 months of real consistent contact. So the fix, I normally suggest this to my clients: export 90 days across every platform, but not the same 90 days. Don't curate. Obviously, be respectful and just sift through it, and very intimate messages or pictures, set them aside. We don't want to send that to IRCC. Submit the boring stuff. The did you eat, for example, or I'm running late texts, or even a little bickering, you didn't get the right type of toilet paper. Officers are looking for a real rhythm, not a greatest hits compilation. Now, we are at evolution, the last quiz. this is the scenario. Work permit expires March 15. Engagement announced March 22nd. Sponsorship filed April 30th. What does the officer look at first? A, B, or C? If you can put it in the chat, that would be great. I promise you, the last quiz. Okay, Marco Polo says B, B. Thank you so much, Zubair. You're always present here. Yes, you are correct. It is B, the timing. And here's what people consistently underestimate. IRCC has your entire immigration history. Every visa, every entry, every exit, every previous application, even if you flagpoled, it's right there. A relationship that formalizes the weak status is lost as a parent. Officers have seen enough times that I'm willing to bet has its own section in their training. Being genuine doesn't exempt you from explaining the timing. It just means you have a real story to tell. So just tell it. The last of the red flag now, here, the evolution. This one trips up genuinely real couples all the time because timing isn't a matter of fraud, but unexplained timing looks like it might be. And that's enough to make a file significantly harder to get across the line. Now, on the risky version here, we have a relationship formalized right when the status changed with nothing, no context around it. No evidence of a shared future being built before the deadline hit, and immigration history that's vague or conveniently incomplete. Now, prior applications or previous sponsorship history that is just doesn't appear there. No shared financial footprint, no joint expenses, no transfers, nothing that shows two people actually are building a future and a life together. Now, that file has exposure. It can still be approved, but it's going to work a lot. You're going to have to work a lot harder to get there. Now, strong evolution, on the other hand, owns the timeline completely. A full, honest immigration history, explained and not hidden. A proof of a real shared life already in motion. An address together if you both live in Canada. Employment, financial integration, messages where you actually discuss your future. Housing, family, are we getting a dog? Are we getting a cat? What comes next? What is the next step after, let's say, your spouse becomes PR? The conversations that prove this is a life plan and not a contingency plan. And this is my most important piece of advice for this particular portion. Don't try to hide an uncomfortable timeline. Officers have seen this pattern hundreds of times. They know what a hidden timeline looks like, and hiding it raises more questions than the timeline itself ever would. Just own it, explain it, surround it with everything that proves this is real. A well-told complex story is not a liability. In the right hands, it's actually an asset. So think about it like that. Now, here's everything at once. The trace diagnosis map. Togetherness with the first red flag where, you can't describe each other's lives. Cohabitation falls apart under questioning. The relationship history where the timeline looks engineered and not organic. The affirmation, next session where you don't have any witnesses or not very strong and looks like a private arrangement more. The communication, red flag 4, where let's say you have 60 days of text for a 3-year relationship. And the last one, evolution, where you're engaged, let's say the week the visa ran out, or there's no actual plan of how you're going to move forward with your life, what the progression of your life would be once the principal applicant becomes a permanent resident. So when you look at the file through all these 5 pillars at once, the exposure becomes quite obvious, right? The question is whether you find it first or an officer does. And I'll let you figure out which scenario is basically most expensive. Here is what I want you to actually do with this. Before any of you submit any file that goes anywhere, yours, your clients, your friends, whoever, run a trace self-audit and be honest. Rate the evidence, not the feelings. Not how in love you are or they are. That's, actually documented. 1 to 5, each pillar. Write it down, think of it, and think in terms of what documents you have, what documents you can produce to cover everything in here. Now, typically, one category of 3 or below, that signals a gap. I typically advise to have somebody review application package, immigration professional or not. You can have, a friend, your grandma, a parent, someone that is not directly involved in this application and can see it with fresh eyes and being objective. If you have 2 or more at 3 or below, don't submit that file without professional eyes on it first. Truthfully, the exposure is real there, but it's fixable. Only if you catch it before it's sitting in an officer queue. This is exactly the audit I run with every client before we start building a single document, because I'd far rather spend an hour finding the gaps than spend, 3 months trying to fix the outcome after the fact. That's the difference between, doing this well and doing this hopefully. Now, if you want to, you can put in the chat if you had the chance to rate your own file already, and put in the chat if you feel like you have a weakness in any of these categories. And then, during the Q&A, maybe we can address it. It's up to you. I understand this is a very private matter. So this would be fine. Now, I want to leave you with something I generally believe in. A difficult file doesn't mean a doomed file. It means the story needs to be told better, more completely, more clearly, with the right evidence in the right places. Everything is fixable, almost always. I personally specialize in the files that look complicated on the surface, with fast timelines, with prior applications, previous gaps in status, cases where someone looked at the situation and said, there's going to be a problem. Those are exactly the files I love working with, because a complex file built correctly is not a liability. It's just a story that needs, a skilled narrator. So if anything we covered today applies to your file, please, that's what, consultations are for, working through your specific situations, not just a general picture. For everyone that joined me today, I have a 20% promo code for consultation. It's called Summit. You can scan the QR code right here. I would actually love to hear from you. So yeah, if we can go and see what questions do you guys actually have. Hello. Okay. Thank you, Olena.
Okay, thank you, Cosima. I have my video glitching. Oh, here we go.
You're here.
Okay, thank you so much. I put the links in the chat just so they're clickable, so you can find the links there. And yeah, we have some questions. So question in the chat, number 1 is, let me just I think it was one up there from Rummy. When you believe an officer made a mistake and you can prove it, do you prefer an appeal process or resubmission or reconsideration?
That's such a multi-layered question. So first of all, it depends. It depends what stage are you in, right? From your question, I assume your application was refused already. That's how you found out an officer made a mistake. Now, the appeal option is not available for every type of application. Even for spousal sponsorship, right? It depends whether you filed inland or outland. We're going to have during today a deeper conversation about that later. My colleague Arsheen is going to discuss the inland and outland. A reconsideration, sure, I always encourage a reconsideration. However, keep in mind one thing, no matter the type of application, the officers and IRCC, they're not obligated to respond. They might respond, they might not. So if you don't hear back, there's actually nothing you can do about it, right? It's a shot in the dark. Now, if they do respond, they might actually have a program manager do the review of your file. They might not, they might deny it. One thing I want you to keep in mind when you do a reconsideration, you cannot introduce new evidence. You have to make your argument based on what was initially submitted in the file. So when you say they made a mistake and you can prove it, if you can prove it with documents that were initially submitted with the file, then absolutely. If you want to introduce something new, then resubmission would be the best route to go about it.
Yeah, for sure. Okay, let's see other questions. What about if the couple don't chat often, but do more of video calls and you have kids together who are Canadian citizens?
Okay, that's actually a great scenario. You have a lot to work with there. There's logs of video calls, right? Even more than that, I typically tell my clients to start recording their sessions, run it through a transcript program. Then you actually see it on paper. It's like, and not only audio, curated, right? Make sure, you know, they're not very, very personal or indecent things in there, and use that. The fact that you guys have kids helps a lot. It's strong. It shows a way stronger type of relationship. There's actually a question in the document checklist for spousal sponsorship if you do have kids together. That question is there for a reason.
Yeah, for sure. Okay, one question also from Ivana. Married for 16 years to Canadian husband with 3 children, all Canadian citizens. Now, what proof of relationship do I need aside the requirement proof, aside the regular requirements, to convince an officer in my application for PR from Ghana?
16 years is a long time there.
That's the first thing that I was thinking about as well, yeah.
Also kids, right? So again, there's another question on the document checklist. Have you and your spouse been married for longer than 2 years? Again, that question is there for a reason. It shows a stronger relationship, clearly, than just a general one. Aside from general evidence that every spousal sponsorship should include, I would advise you addressing why for 16 years you weren't interested in becoming Canadian PR. Is it because you and your husband and your kids lived in Ghana? Is it because I don't know, maybe you worked for a Canadian company and you have back-to-back work permits and everything was going great. And, you know, with 3 kids, you barely have time to breathe, not to mention file an application. But provide a reason, because I am personally wondering, why did you guys for 16 years didn't file for a sponsorship? And my rationale is this: if I'm wondering about something, an officer will for sure too. So, yeah, I actually think that your case is more straightforward than others.
Yeah, for sure. Okay, now a fun question. How can couples effectively prove a genuine relationship for spousal sponsorship when there is a 30-year age difference?
There are ways. Age is just one factor. You can basically build on the other pillars around the trace system, right? How the younger partner, you know, is the kind of personality that seeks maybe someone more of a protector, someone more of a mature mindset, right? It can be a cultural thing. I don't know the specific of the situation, but I can tell you this: if you guys are in a relationship and you genuinely love each other and are in this for quite some time, clearly 30 years age gap is not a problem for you, right? It's not. So sit down together and think about those elements. Why are we together? Why do we love each other? I know, like, couples don't really ask themselves that. You know, what do I love about you, my partner? Right? The way you treat me, the way you take care of me, that is your proof in your relationship.
Yeah. Sounds good. Okay, question from Lisa. How many photos, captioned and dated, would you recommend as part of the spousal sponsorship file? Because there is a file size limit.
There is a file size limit. That's true. And the way I work around it, I literally copy paste the photos in a Word document. That's where I normally edit the dates, place, location, and then you just basically save it as a PDF that will heavily reduce the size. Another thing that I want to point out, there are several categories in the checklist where you can upload or use photos. Specifically, the photo category tells you no more than 20 pictures. However, doesn't mean that you cannot insert pictures in other places as proof of your relationship. So if you have a very, very long relationship, I find that 20 pictures are not enough, because I typically look for like 1 or 2 from each year or each. So just see what fits better for you. But keep this in mind, you don't necessarily have to limit yourself to 20 pictures. There are creative ways around it.
Yeah, for sure. Okay, now a bit more complicated question. What can be done if principal applicant has non-accompanying dependent child not in their custody, and the child doesn't want to get the medical done?
That is such a funny question, because I'm actually working on a sponsorship right now that previously had this issue. It was even more complicated than that. So the child was initially accompanying, then the other biological parent basically didn't want to take them for the medicals, so they couldn't do the medicals, being a minor, right? And yes, we all know, even the child or the accompanying child is not, the dependent child is not accompanying, all family members have to do medicals. In this situation, I would just document the ways you have tried to get that accomplished. For example, communication with who has custody of the child, whether it's the other biological parent or who can actually bring the child for a medical evaluation. Document that, affidavits, written affidavits, notarized, like not just a letter in a Word document, notarized from people in the family that know about the situation. I'm sure, you know, if you do all of these right, everything will work out. You can't really get refused because another person can't take your child to a medical examination. And something here that maybe you want to keep in mind for the future, the age limit for an accompanying child, it is 22 years old. So you actually have 4 years from the time that child turns 18 until the time that child turns 22, where they're legally an adult. They can take themselves to a medical. So at that point, you can apply, if you want to, for a dependent child sponsorship, a standalone sponsorship, if you at that point want to bring your child to Canada. So yeah, that was a little more complicated.
Yes, that's definitely more complicated. Okay, let's do, I think we have about 4 minutes here. So,
One more.
yes, let me see.
While you look for one, I'm going to respond to, I think, Liza, because it's a very quick one. Would you recommend statements from the couple and friends relative to be notarized? I normally don't ask my clients to notarize them. However, every person that writes a letter, full contact information and copy of their ID right there within the letter. And that's it. Don't spend your money on notaries.
Yeah, for sure. And another quick one, does the child 10 years and below do medical?
I don't know on top of my head.
Yeah, they do. Everybody does medical, for sure.
Even babies, right? Biometrics have, I think, 12 or 14.
14, I think, biometrics.
Yeah,
something like that.
That's correct. That's correct.
Yeah.
One more thing I want to say quickly about medicals. For the principal applicant, be careful if you're pregnant during the spousal sponsorship, because part of medicals, you have to do x-rays. So that's why, again, there's a question there in the document checklist. If you're pregnant, you won't be able to do the medicals, right? So keep that in mind when you do your timing.
Yeah. Okay, let's take this last one. So I'm on a study permit and my boyfriend is Canadian. We are getting ready to apply for spousal sponsorship before I graduate. And we have been a common law for just over a year. We live together, but not leasing, as he owns the place. And I don't pay the house bill, but we are on the same insurance. Could me not paying the bills at this place become an issue? Is there anything else we should watch out for? And if it helps, we've been in a relationship for over 5 years, and our parents and friends know about our relationship.
That's great. First thing I want to address, in this situation, he's not your boyfriend. He's your common law, okay? So you have to get into that mindset, especially when you're like starting to prepare for a spousal sponsorship. Secondly, to me, it makes sense that you're maybe not contributing the same way he does, right? To all financially. First of all, he owns the house, right? Well, I don't know if there's a mortgage there happening or parents are paying it, but clearly, you're not contributing to that, which is fine. You were a student, so you're not working, you're not making money, right? Again, it makes sense. How from thin air, what are you supposed to pay it with? right? Make sure you explain this clearly. That's why this happened. We don't have financials. However, proof of relationship, proof of shared address, your phone bill, right? Does your personal cell phone bill, do you have the same address as he does? Your tax, your T4s and notice of assessment, you have to file those, right? You're a student, there's probably tuition happening there. You have to file your taxes. That is a government document that shows both of you have the same address. It doesn't necessarily have to be a lease. It doesn't necessarily have to, you don't necessarily have to show you're sending him money and he's sending you money. If you have financial transactions from him to you, that is great. Also, parents know about this. How do parents support your relationship, right? You're young, you're still a student, right? Do they support you financially? Are they willing to support you in the future financially? Do you guys live in the house that they own, right? Like, there's so many things here that you can work with. I don't want you to get scared about this like trace system. I want you to see where an officer may have questions, and it's great. That's exactly what you're doing, and answer it before your file gets on their desk. So you actually have a lot to work with there.
Yeah. All right. Well, thank you so much, Cosima. I really appreciate it. I'm just gonna put one last time links to contact Cosima if you ever want to. You can also find her on TikTok. You can just type name Cosima RCIC and she will just pop up at you, and I'll send the link in the chat in a bit as well. Thank you so much.
Thank you so much for having me, Olena. Thank you, everybody. If you have any more questions, you can find my details either in the YouTube description or in the chat where Olena put it here, and follow me on TikTok. See you soon.
Thank you so much. All right, we're ready to transition to our next speaker, which I'm super excited about. So we're going to talk all about inland and outland spousal sponsorship. So let's welcome Arsheen here. Arsheen. Okay, you're muted.
Thank you. Okay, I said I'm gonna imagine everybody clapping, saying, "Yeah, okay, welcome, Arsheen." All right, that was an amazing presentation, Cosima. I was
So
blown
good.
away. Oh my goodness. Wow. I'm glad that there is a recording because I'm definitely going to listen to her again. This is gold. Olena, thank you for organizing this. This is gold, and I hope everyone who's watching is really excited because really this is gold. The information, the analysis, this is really good stuff. Okay, so
Yeah,
let's start.
perfect.
Let's share my screen.
Yeah, and while Arsheen is sharing her screen, just want to remind everyone we've had some questions that we didn't get to, and we will be answering questions after Arsheen's presentation, and then after Carolyn's presentation, we have a bigger Q&A session. So just stick around if you want answers to your questions, as we have speakers who will be joining and rejoining to answer your questions, and it's always useful to get to like really answers, for free from multiple RCICs. And and for us, it's also so much fun to make sure that we're able to help you guys, because by the end of the day, it's just our way to serve the community of immigrants. Okay, yeah, we can see your screen. Should be good. Can you try changing the slides, because we've had problems with that today, and just to make sure. Yeah, all good, all good. Yeah.
Okay,
All right.
awesome. Yeah. And Olena, it's also, I really think if you've been in RCIC for more than a year, it gets to you, and then you're just obsessed with immigration. And talking about immigration is just, oh my God, it's fun. You want to talk about immigration. Okay, so today, everyone, we are going to talk about inland versus outland sponsorship. And I feel that as an RCIC, this is all I talk about. Really, the truth is, when I first became an RCIC, I think that was like 6 years ago or 7 years ago, I didn't fully understand this. And I would go back and forth and back and forth, and I would see And I would watch, just like all of you in the audience, I would watch other RCICs in their videos, in their TikTok videos, in their YouTube videos, explain inland versus outland. And they would explain it inland, it's simple. If you're living inside of Canada, you apply inland. And if you're living outside of Canada, you apply outland. And they would say, it's so simple. But I knew that there was more. And that's what confused me. And that is what we're going to talk about right now in this session, because there is so much more. Okay, so let's go to the second slide. Okay, so my first question to everyone, how confident do you feel about your immigration application here? So you don't have to like write down the actual answers here. I want to know how confident you are. Just type down like 1, 2, 3. Are you super confident? Are you somewhat confident? Are you okay? So we have somewhat confident, and or are you drowning in doubts and you just want, and that's the benefit of attending these sessions where you can just ask, and then you can even ask follow-up if you're quick in typing. Okay, we have a lot of 1 and 2. All right. Okay, and if you have complicated cases, then it's I see gray blocks on the screen. Okay.
Yeah, I see them too. It's weird. Maybe maybe next slide will be better. We'll
I
see.
know. Hopefully, let's see. Okay. No, where are we doing? Okay, I see what you get about the changing of the slides. Okay. So, what's going on? Okay, let's do that. Okay, what about this? Poll number 2. Now I want to know from everybody, what do you think the difference is between inland and outland before I accidentally just give it away and then the whole rest of the presentation is kind of useless. But what do you think? Everybody type in 1, 2, 3, or 4. What do you think the difference between inland and outland is? Is it really out? Number 1 is outland if you've never traveled to Canada, and so obviously you're outside of Canada. 2, inland just takes longer to process. Right now it's like 24, 25 months. 3, choose inland if you're in Canada and outland if you're outside of Canada. And you'll see people actually explain it like that. And number 4, I actually don't know, and you're here to find out. Okay, so let's see. What is it? Okay, 3, 3, 3, 3, 3. Yes. Okay, so this is exactly what I'm here to dispel and to clarify. It is not number 3. Although you will see this, you will see lawyers explain it like this, you'll see RCICs explaining it like this, you'll see a lot of people explain it like this, that they'll say choose inland if you're in Canada and outland if you're outside of Canada. But it's not like this. Okay, let's go to my next slide. Okay, so the real truth. What is the real truth? Inland versus outland is not about where the principal applicant is living. It is actually where you want the application to be processed. Do you want the application to be processed inside of Canada or outside of Canada? And really, you're going to turn to me and you're going to say, Arsheen, I don't really care where the application is processed. It doesn't really matter to me where IRCC wants, what office do they want to process it at. And and this is where it gets complicated. So it's really not where you want it to be processed. Where you want it to be processed, there are implications, there are ramifications, there are consequences for choosing inland or outland. And that's what I want to go over. Okay. So, inland versus outland. Okay. So, where are we? Okay. So, the consequences are, okay. So, actually, no, I don't want to do this slide. Okay. So, inland versus outland. Sorry, I am confusing myself. Okay, so the factor, okay, let's go through this. Okay, so for inland, your spouse, or you must, so if you want to select inland, you must live in Canada. If you want to select Outland, you can live, like I'm talking about you when I'm talking you, it's the principal applicant because that is the principal applicant. That is the main applicant in this whole sponsorship application. So when I say you, it's the principal applicant. If the principal applicant lives inside of Canada, they can do inland or they can do Outland. Okay, this is the biggest tip of this entire presentation. If you're living in Canada, you don't have to go with inland. You can do inland or Outland as well. Okay. What are the advantages of doing inland is that the advantages, okay, I have a slide here that is better, but I don't know why I didn't. Okay, let's do here. Okay, eligibility, yes. Which stream can you use? Okay, so inland requirements, the spouse, so spouse is the principal applicant, must physically be in Canada. So they must be living in Canada and they're living with their sponsor in Canada, right? Outland requirements, the spouse can be anywhere in the world. They could be in Canada or they can be out of Canada. Inland requirements, spouse must have a valid temporary status in Canada. So usually principal applicants, if they're in Canada, they are students or they're on their PGWPs or they're visitors and they should have valid status. And if they're in Canada, they must be cohabiting in Canada. They must be living together in Canada. And then the sponsor, just general eligibility, must be a Canadian citizen or a PR. And the sponsor must also be residing in Canada. Okay. And these are actually the eligibility criteria of the spousal open work permit. Okay. Sorry. So, okay, so now I just want to contrast. I hope you're all still with me here. I want to contrast inland versus outland. Okay, inland, the major differences of inland versus outland is here. Inland, you as a principal applicant cannot travel inside and outside Canada so freely. Maybe you can leave Canada for a weekend, but according to official IRCC communication, principal applicants cannot leave Canada once they have submitted a spousal sponsorship, an inland spousal sponsorship. However, if they just ticked outland instead of inland, then they can leave Canada and return to Canada. So this is something major to consider for principal applicants. Would you be exiting Canada? Do you have family back home that you need to visit? Or are you working in a job where you need to enter and exit Canada frequently? And if that is true, then Outland is an obvious choice for you. And it's just so that you have the ease of exiting and entering Canada. So that's one of the number one differences between inland and outland. So there's three major differences. Number two difference is inland has no right of appeal. And I think Cosima touched on that. So if you have a high risk application, so let's go back to the 30-year age gap, right? Let's say like these are major red flags, right? That if it's not explained properly, that could warrant refusal. Or let's say you have previous refusals. If you have major red flags in your application, you don't have a right to appeal if you went the inland route. So that is something to be aware of. But the biggest consequence of choosing between inland and outland is processing time. And I highlighted it in red here. Inland is an average processing time right now of 24 months. And outland is 15 months. So 15 months and 24 months doesn't mean it's actually going to take that long. And it may very well be shorter, or it might be a bit longer. But these are the average past processing times. And we can definitely see outland is a lot faster. So if you are a couple that is residing in Canada, even if you're a common law couple in Canada, you have a choice to choose inland processing or outland processing. And if it's outland processing, that means the actual processing of the file is physically going to happen in an IRCC office outside of Canada. Typically, wherever the visas in your country are processed. If IRCC has a visa processing center in your country or in the neighborhood of your country, that's where it's going to be processed. If you choose inland, they all get processed at the same Canadian, inside of Canada, visa processing centers, which is why it's so much longer, because everyone who chooses inland gets to those centers inside of Canada, whereas outland, it's distributed all around the world. All right, so going back to these three major differences. One major difference is the principal applicant cannot travel in and out of Canada freely. Number two, they don't have the right of appeal. If you face a refusal and you did an inland, you could do a judicial review, but that's if the officer made a mistake and if you can prove it nicely. You can even do a reconsideration, but then just as Cosima said, like there's nothing that says that they really need to consider the reconsideration. So they don't, so your options if you run into a refusal are limited with inland. Okay, the third major thing, which is actually the first major thing, is the processing time. Look at this, 15 months versus 24 months. So you can see by the way I'm talking, and I honestly think it's so obvious if we just look at the screen here, that I'm a major proponent of outland. Even if you're inside of Canada, to do outland. Again, every case is different, so it's best, you know, the strategy of having a consultation, if like even if you want to do this on your own, spousal sponsorships, the strategy of having just a consultation, paying like somebody what, like $200, and just get them to map it all out for you, and then you follow the map. But inland versus outland is the first question you need to answer. Okay. There are some other things that we have to go over with inland and outland sponsorship. Okay. All right. I have another question here. I am wondering, where are you in your spousal sponsorship journey? Are you just like buried in paperwork right now, trying to like figure it all out? Or are you just researching and like going to different seminars to figure it out? Or did you already submit and you're holding your breath, waiting to figure out what's going on? You know, after you submit, you just hold your breath. Oh my God, what did I do here? Okay. So let's see, where are the responses? How do I find the responses? Chat. All right, responses. Okay. So already submitted, holding your breath. Yeah. You see, and then how long do you hold your breath for, right? 24 months, 15 months, right? And some people are collecting evidence. Yeah. Okay. Awesome. So we're all around the place right now. Okay. All right. Okay. So now, what about this? What about spousal open work permits? So, did you know? Here's some like fun facts, as my kids say. Before 2023, spousal open work permit was tied to inland sponsorship. So you could only apply for a spousal open work permit if you opted for the inland spousal and common law partner stream. And if you opted for inland, then spousal sponsorship would apply. But in 2023, Minister Sean Fraser changed things, and that changed the whole spousal sponsorship landscape a lot. That today you can apply for a spousal open work permit whether you are inland or outland. It doesn't really matter. So at that moment, I don't think the minister really realized that he gave up the one advantage of inland. Because right now, it doesn't look like there's any advantage of inland. Because inland, you don't have the right of appeal. You can't travel in and out of Canada. It's so much longer. And in Outland, you can apply for a spousal open work permit. So why wouldn't anybody do Outland? So here we go. Let me go through the eligibility criteria of spousal open work permit. And I think over here, this is the spousal open work permit eligibility criteria. Or I don't have it here. Okay, so spousal open work permit eligibility criteria is that number one, you're in a genuine relationship, which is the whole premise of this entire application, right? So that's check for everybody, right? You're in a genuine relationship with your sponsor. Number two, you're in Canada. Okay, so you're inside of Canada. Number three, you are living with your sponsor in Canada. So if you meet all of these three, and number four, you have received your AOR. And when you meet all four of these eligibility criteria, you can apply for the spousal open work permit. Okay. And when to apply, you apply once you received your AOR. And key caveat here, spouse must be in Canada on valid status, and that could be visitor status. Okay, so I want to go over something. I want to go over, okay, this framework of, I have some possible situations, and then we can like analyze whether inland or outland is better for that situation. Okay, so the situation is here. Is your spouse in Canada with valid status? So let's say this is so typical, the spouse is a student or on PGWP, right? Okay, they have valid status. They're a strong inland candidate because they are living here, but they're also a strong outland candidate. Like either or is good. Does the principal applicant need to travel in and out of Canada frequently? If yes, they have to travel in and out of Canada, then I would not suggest doing inland because you can't travel in and out of Canada freely. But if you do outland, you can travel freely in and out of Canada, provided that you have a valid TRV to return to Canada. Does the principal applicant need to work ASAP? Okay, so this is a situation where, again, just like the first situation where you are in a relationship, your spouse, the PA, has a study permit or a PGWP. PGWPs expire, and this is the major stress for people with PGWPs. They have one eye on life, the second eye is on the expiry date of their work permit. And if you are applying for spousal sponsorship, you have a solution to that, but you need to time it well. And this is where strategy is key. You need to time it so that you can get your AOR and you can apply for the spousal open work permit, which would be an extension to your PGWP. And if you apply for the spousal open work permit before your PGWP expires, then you're on maintained status and you can continue working. You don't have to quit your job and wait for the 6 months of processing, 6 to 9 months of processing of the spousal open work permit. You can actually just keep on working all the way till you get PR. All right, so that timing is key. Okay, are you a common law couple inside of Canada? The best fit is inland, but only if both sponsor and PA continue to live together outside of Canada. Well, no, you could, this is wrong. You could either or, you can do inland or outland. Again, I would say outland would be the best just because of the option that you have less processing time. All right, let's go to the next one. Okay, so some mistakes that could cost families dearly: not timing your spousal open work permit eligibility with the PA's work permit expiry. So we just mentioned that. Another thing, assuming Outland is safer just because, yes, okay, this is a good point that I have here. Okay, so one drawback to Outland, and this is if you are truly Outland. So what I mean by truly Outland is if you're living outside of Canada and you've never come to Canada, and if you wanted to, after you get your AOR, which is your acknowledgement of receipt, which comes about 1 to 2 months after you submit your spousal sponsorship, you get your AOR. That opens the doors. If you're in Canada, you can apply for the spousal open work permit. If you're outside of Canada, then you can apply for a TRV to come to Canada and visit your spouse. Now, I just want to give a fair warning that TRVs are not guaranteed applications. Just because you have a spousal sponsorship application in the pipeline doesn't mean that you're going to be approved for a TRV. And if you're refused a TRV, it doesn't affect your spousal sponsorship application at all. It doesn't affect it. But it is the difference between applying for a temporary resident visa and permanent residence. Temporary residence is you're trying to prove to the visa officer that you are returning to your home. And if you cannot prove that you are very, very well established at home, then sometimes visa officers refuse TRVs. So that is something to be aware of. Now, okay, so now this mistake, choosing inland when outland is better. Many applicants assume that because the principal applicant lives in Canada, they must choose inland. This is a big mistake, especially if they want to travel outside of Canada or have a higher risk application or want PR faster. And who doesn't want PR faster? That is the number one obstacle. Okay, another mistake I've seen is assuming that you can switch streams mid-application, and you can't. Once you decide, that's it, you decide. And that is actually the first question that IRCC asks you when you go on their portal. They ask you if you want inland or outland, and it's the first thing. So choose wisely. This is a big decision. All right, here's another costly mistake is assuming inland sponsorship protects against removal if out of status. Okay, so one thing I want to say, now what happens to people who are not in status? They're in Canada, but their work permit already expired. Or let's say their work permit expired or their visitor, their visa expired not like 2 months ago, like 2 years ago. What if they've been illegally living in Canada? Is spousal sponsorship open to them? And it is open to them. And it's open to them because of a public policy under the inland stream. So if you don't have status, you would appeal for to IRCC for humanitarian consideration because of your lack of status under the public policy that allows those without status to apply for spousal sponsorship through the inland stream. But like I said here at this most lowest point here, just because you've applied for spousal sponsorship and that there is a public policy, it doesn't mean that you're protected from removal. If there's a removal order against you and CBSA actually comes after you, they have right to remove you. So it doesn't protect protect you, although it is an avenue to get back into status, especially with after you receive your AOR and then you can submit a spousal open work permit. Okay. Okay, we did this one. Okay, final poll. What is the most daunting part of spousal sponsorship? What do you think? Do you think it's gathering all the relationship proof? Do you think it's the cost? Do you think it's the waiting and the uncertainty? Or do you think it's understanding what forms to file, what forms to include? Or is it being separated from your spouse? What is the most daunting part of all of it? All of the above. The waiting and uncertainty, seriously. The waiting kills you. Yeah, definitely. All right. So I didn't want to start with this, introducing myself because I didn't want it to be all about me. But to introduce myself, my name is Arsheen Devjee. I am a regulated Canadian immigration consultant for 6 years now. The founder of Arsheen Immigration. I specialize in spousal sponsorship, express entry, and citizenship. I handle every case personally. And if you have your phone handy, follow me on TikTok right now. To read more about me, my website is here at the bottom. But really, the best way is to follow me on TikTok. And oh, yes, today is my birthday. And I thought, let me put some gifts in to acknowledge it and to celebrate it with all of you. So 20% off spousal sponsorship consultation. So if you want to scan this QR code, or you can visit my Calendly site, which is on here, Calendly/Arsheen Immigration. And the promo code, oh my goodness, look at that. I have Summit 2027. No, it's Summit 2026. And really, this is valid only until Friday night, Friday, 11:45. So go to the website, calendly.com/Arsheen Immigration, enter for spousal sponsorship consultation. There are other consultations there, but if you go to spousal sponsorship and enter in Summit 2026, you'll get 20% off. And there's one more for my birthday, because it's a big birthday. I wanted to provide my letter of support guide. So this is what I actually give my clients. So when people hire me, I take them through, like, okay, you have to get all their information, and then after that, just like Cosima was going through her trace steps, I also have 4 steps that I take clients through to prove their relationship, and one of them is social proof, because you need emotional, physical, social, and financial proof. And social proof is to show that in society, even in your family and in front of your friends, in work, the two of you are considered a couple and recognized as a couple. And a very high-ranking proof to submit are letters of support. But just like Cosima said, having letters of support that just say, like, we wish the couple well, and we were very happy to see that so and so, like, that they hooked up, and those kind of letters are not going to cut it, and you need personal letters. And my letter support guide is amazing. The first time I gave it out, I actually was fooled. I thought, and I said to the client too, I'm like, wow, your family writes really nice letters. I think they were from Nigeria, and I was like, wow, Nigeria has people write very detailed letters. But then the second client, same thing. I was like, wow, even they write really nice. And then I realized that, hey, it's the guide that I give them. And it's basically a whole bunch of prompt questions, and you give it to your family, and then they answer it, and then they come up with really nice letters that are not generic and that are very personalized. So, how do you get this guide from me? Follow me on TikTok. It's Arsheen_immigration. And then send me a DM and just say summit, and I will send you the guide. It's important to send me a DM and not just comment, because with a DM I can respond to you and send you the guide. I hope my explanation was useful for everyone here. And I hope I was just able to dispel this one myth that inland does not mean, like, you don't have to apply for inland only if you're living in Canada. If you're living in Canada, Outland is available and inland is available. Outland is like almost half the time and has so many more benefits. So consider it well. Okay, I'm gonna hand it back to Olena.
Thank you so much, Arsheen. It was great. We have a question, logistical question. For those of us who are not on TikTok, how do we get the guide? Maybe if you want, you can type out your email address in the chat if you are okay with that.
Yeah, I can.
Or you can always, for those who are watching this recording on YouTube, you can always comment under our YouTube video, and we will try to get it to you and connect you with Arsheen. Yeah, perfect. So Arsheen put her email address in the chat for those who are not on TikTok. All right, so we have some questions here, and yes, okay. So I'm just gonna go with the first one that I see here. Principal applicants applies Outland and is outside of Canada. They travel to Canada on a visitor after receiving AOR. Can they apply for open work permit?
Yes. Yes. Okay, this is the best combination of everything. If you could map out like a dream spousal sponsorship, it would be that you're outland or inland, whatever, you're outland, you're living, like, you're truly outland, you're living outside of Canada, and after you get the AOR, you apply for a TRV, you actually get the TRV, you come inside of Canada, you live with your sponsor. Now, when you apply for a spousal open work permit, you have to prove that you're living with your sponsor inside of Canada. So you got to get like all those documents that are like proof of address. The easiest one to get is a bank account. So have your spouse add you so that you have a joint bank account. And that's great financial proof too, to show financial interdependence. And yeah, you can prove you're living with your sponsor, you're in a genuine relationship, and you're inside of Canada. Spousal open work permit is yours. Well, you can apply for it.
Sounds
Okay.
good. Yeah, that's great. Okay. Okay, this is a good one. I am in Canada with 3 months remaining on my work permit. If I submit an Outland spousal sponsorship application while in Canada, can I still apply for an open work permit after receiving AOR? And how can I would it be maintained status then?
If you can apply for a spousal open work permit before your work permit expires, yeah.
Yeah, if after receiving AOR.
Yeah, after receiving AOR.
Yeah, and then it would be still in
You would
Canada
be
work permit.
maintained. Yeah, then, this is the thing, right? So just because you submit the application doesn't mean you get it right away, right? It just means you submitted the application. So same with work permits. So you submitted the spousal open work permit application, but because you had a work permit application, the spousal open work permit application is like a work permit extension, like you're on maintained status. But if your work permit were to expire, and then the next day you get your AOR, and then the next day you apply for spousal open work permit, like you miss the boat, and then you have to wait a whole bunch of months. I think it's 6 months for the spousal open work permit to process. And that is a really unfortunate situation, especially because you've been working in your job. What do you tell your boss? Like, I have to like leave for 6 months because I didn't time my applications.
Yeah, for sure. Okay, so let me just see. Okay, so a little bit more complicated, bigger question. I don't know if you can see Q&A box,
Oh, no, I didn't.
if you can find it. It's been harder to
Q&A.
find it for
Okay.
some people.
There we go. Here's my
And
question.
it's the question, I'm the PA and I have multiple entry visa, but I'm planning to apply for inland common law. Me and my boyfriend have been in a relationship for 5 years and common law for 4 years now. And I have postgraduate work permit that's expiring April 2027. So how should I apply inland or outland? Because I'm worried that outland might be confusing for IRCC officers. Like, yeah, that's, would be my question as well. Like, if you're in a common law relationship inside Canada, can you apply outland still? And then what kind of proof they would ask if I can apply for outland?
You can apply for Outland. However, I would explain that I'm applying for Outland because of like A, B, and C, and literally because the timing it's faster. I live with my spouse or my common law partner in Canada, and please see the attached documentation A, B, C, and D to prove that. And then I would say like literally like because of the consequences of inland versus outland, I'm applying for outland because of that. Mind you, if you're living in this is the other thing, right? There's two different situations. When you have a sponsor that's living inside of Canada and you have their spouse that's living outside of Canada, that's one thing. They're separated. So that's a major stress on the relationship, right? When you're already together and you're inside of Canada, and then you have a spousal open work permit and you're working, what is the difference when you get your PR? What is added? How is your life going to change? It's not, right? Like you're just going to continue working and continue living together. So that's the other thing. Like, is it really a big deal then that your sponsorship application takes so long if you're already together and you're already living together, like being on a work permit and PR? Unless it's just like peace of mind that you're a PR rather than a temporary resident.
Yeah, and the way I think about it is that if you are a common law common law couple inside Canada, and you are applying as an outland application, like ultimately, it doesn't matter what you explain, doesn't matter how you do it, doesn't matter how great your application is, it's going to be confusing to IRCC. Like it is, because it's not a straightforward way to do things. And my question, it is possible you can do it, but my question would be, is that it is worthwhile for you to confuse RCC and to really make it like more complicated rather than just apply like a straightforward way, inland common law, inside Canada? Yes, longer processing time, but I would
But it
just
doesn't
weigh
make a
out.
difference. Yeah, does it really make a difference?
Yeah,
Right?
I would
'Cause
weigh
they're
out like
together.
the implications and risks.
Mhm.
But that specifically is very specific to common law application, because if
Mhm.
you married, then it really like the risks are not that big. Common law, I feel like,
Yeah.
I would worry about it if it was my client and I applied to Outland.
Mhm. You would apply inland, yeah.
Yeah. So I would ultimately,
Mhm.
personally, I would recommend applying inland. Again, it's a super
Mhm.
just a kind of matter of judgment here.
Mhm.
But
Mhm.
if I was in this person's shoes, I probably would apply inland.
Mhm.
Okay. So let's see some other questions. Okay, good question. My boyfriend is currently unemployed because he's running his own business, but there's no profit. Do we need to show proof of funds, or how do we tell IRCC that he has savings?
Well, you tell IRCC that he has savings by showing it, by showing like the statements. And so basically there's no financial minimum that the sponsor has to meet, but there is, because the sponsor is agreeing to an undertaking, which is they're promising to provide for their spouse in all ways, like in provide for them so that their spouse doesn't dip into welfare. That is the main concern of IRCC. They don't want to have, immigrants come to Canada and then be a drain on the social welfare system. So if the sponsor needs to prove that they have enough funds to provide for their spouse. And I always go with LICO. If you just Google LICO, which is low income cutoff, you'll get to the StatsCan page of low income cutoff, and then they have a nice chart of, depending on how big of a city you live in and how many people in your family. So the sponsor has to provide for themselves and their spouse, and if then there's any other dependents there. And so you match up the city size with the size of your family, and then it shows you how much your annual income should be. And then you can basically use that as a minimum. But again, there is no minimum, and you can even remind IRCC saying there is no minimum in your explanation letter. And then put proof of funds, as in like savings. If you have savings accounts, provide those bank statements.
Yeah. Okay, perfect. All right, guys, just a reminder that we will take more questions after our last presentation. So roughly at 2:30, so roughly in 30, 40 minutes from now, we're going to have just the floor open for questions with multiple panelists and speakers present answering your questions. For now, let's say happy birthday to Arsheen. What a great way to spend your birthday as an immigration consultant, to present to people and educate people and help people to get their doubts cleared. So happy birthday. Let's say everyone in comments in the chat section, happy birthday.
Well, thank you. Thank you for the kind wishes.
All right. Thank you. Thank you so much. So we're going to move on to our last presentation that I am personally super excited about, because this is the topic that we don't talk enough about, I think, when it comes to spousal sponsorship applications. So we have Carolyn Watson here talking about conjugal relationship. And I'll be honest, most of us don't even know what conjugal relationship is. And there are actually, a couple school of thoughts of where is that line in terms of spousal sponsorship. When can you actually apply for conjugal spousal sponsorship, and when it would be successful and when not? So Carolyn, welcome to the summit. I'm super excited about your presentation. So let's get this started.
Thank you so much, Elena. It's very exciting to be here. I'm so happy you organized this. So I'm going to talk about conjugal partner sponsorship, what it is, who it's for, and how it works. It's not really a very well-known category for relationships, and I find people either don't think it will apply to them when it does, or they think that it will apply when, they just have a romantic relationship and they're not really that serious. So there's quite a serious assessment done and consideration that needs to go into this type of application. So that's what I'll be talking about. Let me just see if I can share my screen.
Yep, perfect. While you're sharing your screen, Just a reminder for everyone that all the sessions are being recorded. And if you do want to watch a replay, I'm just dropping a link to our YouTube channel. It's all gonna be there. Also, you're going to receive email with contacts of all the speakers. If you ever want to talk to them or revisit or just DM them on Instagram or any other, or LinkedIn or TikTok, and just say hi. So you will receive those emails with all the names, and but also you can find them on our YouTube channel. Okay, Carolyn, I can see that your presentation is being shared, so I think we're all good.
Okay, so it's come up. That's great.
Yeah.
Okay, so just to give you an idea of what we'll cover today, we'll talk about what a conjugal partner is and what it is not. We'll also look at the legal definition and how relationships are assessed. It's very subjective, so don't be too concerned if you don't meet some of the things that I'm talking about. It is a very subjective assessment. Who's eligible to sponsor? Some common situations where it might apply. They're by no means exclusive, so there could be other situations. I'm just going to name the more common ones. How officers actually evaluate these applications. We're also going to look at some real cases that shaped how this works today, so it'll give you a bit of a practical idea of what types of relationships and what types of situations apply, and also what you need to document this kind of relationship. So what is a conjugal partner? The definition and the reasoning behind it. If you look only at what IRCC makes available in the Immigration and Refugee Protection Regulations, it's a very bare bones definition. It's not very substantial at all. So this is the definition in Section 2 of the regulations. A foreign national residing outside Canada who is in a conjugal relationship with the sponsor. The relationship must have lasted at least 1 year, but it doesn't really define what a conjugal relationship is. So for that, we have to turn to the operational guidelines. Now, these are not always easy for most people to find, but immigration professionals have access to these things because we just go after them all the time. So they're very clear that conjugal does not mean sexual relations alone. So if you just have a romantic relationship with someone without any kind of commitment or genuine basis beyond that, it will not be accepted. They are also looking for a relationship that indicates a degree of attachment and mutual commitment. Again, they don't specify this in detail. There's no single moment of commitment or no legal document required, so you don't have to say, we woke up on Thursday, June the 27th and decided we had this relationship. That's not necessary. It's built through intimacy and emotional ties, joint ownership of possessions where possible. That we realize this is not always possible in many cases. Shared decision making. So this is around, decisions as a couple. It could even involve personal decisions with work. It could involve, financial decisions. And it also involves financial support. Basically, the evidence needs to add up to something similar to a married couple. And I know a few people have talked about married and common law relationships earlier, so I won't go into a lot of detail there. But a lot of the things that they look for common law and married people is pretty similar to what they're going to look for in a conjugal relationship without the ability to marry or cohabit. So it's really going to come down to a legal issue or a residence issue. You must also show at least a relationship of 1 year, and it has to be committed and mutually independent. We've kind of addressed that. And the expectation is that once the couple is together in Canada, they will either marry or become common law. So common law is just living together for more than 12 months. When does conjugal sponsorship apply? So this is actually when it gets a little more tricky. I'm going to give you some of the more common areas, but again, they're not exclusive. So it can apply when a couple can't marry due to legal barriers, religious or social restrictions, or persecution. So these could be, legal barriers due to same-sex relationships, or, perhaps in a certain country, people of different religions cannot marry, or they would be persecuted if they did. So that would be, a good broad range of situations where it could apply. It also means that the couple can't live together for 12 months, or they would have a common law relationship. So if they do live together for 12 months, you would go under the common law. The sponsored person has to be residing outside Canada. If the person being sponsored is inside Canada, the expectation is either marriage or they wait until they reach the 12 months of common law. IRCC is concerned with a genuine, committed, monogamous relationship. So I think Sana went over the definition of genuine relationship. So that's basically what they're looking for in a conjugal partner. The same types of things. There can't be any interest. It has to be a committed relationship, all of those details. So basically, conjugal relationships are not a shortcut. It usually requires demonstrating real barriers to marriage or cohabitation, although the law has moved a little bit on this in recent years. And I did start at the beginning mentioning a few different examples of barriers. There really could be a lot of other barriers. Sometimes it could be a case where one of the partners is legally married and cannot get a divorce, but for whatever reason, they can't live in the same country to make it a common law relationship. So it doesn't have to be that complicated. It just needs to have usually some kind of a barrier to either marriage or the common law relationship. Okay, so how is a common law relationship assessed? So they use something called the M&H factors, and the M&H was a 1999 Supreme Court decision that actually helped to define conjugal relationships, whether they were married or common law relationships, around the end of a relationship and the need to possibly pay alimony or child support or divide up assets. And so these are the factors that came out of this decision, and they are usually applied to all kinds of partner sponsorship. So whether it's a spouse, a common law partner, or a conjugal partner, the same factors are usually examined. And they include things like shared shelter. So if you live together under the same roof, that's a good indication that you have a real relationship. Sexual and personal behavior. So if you're living together, you have relations, you do things together, you build your life around each other, that's a relationship. Services. This is a bit tricky because it's not going to be specific to any one person or any one culture, but basically what they're looking at when they look at services is how you relate to each other, how you take care of each other, the things you do to show your affection and support for each other. So, for example, if one of the couple loses their job, how does the other person support that person? What kind of advice or what kind of behavior is associated with supporting that person? That's what they mean by service. They also look at social activities together, and this can get tricky depending on the type of relationship involved. They want to know that people actually go out and do things, that they get together with friends, that they get together with family, that they maybe go sightseeing or, go out for dinner every now and then. That's what they're talking about in terms of social activities. Now, if you're a same-sex couple and one of you lives in a country where that is illegal, these kinds of social activities are going to be limited. So it's something to keep in mind. It's not going to be a deal breaker on this, but it's something that you would have to address. Economic support. I always find this is, one of the more interesting ones because in this day and age, a lot of people are financially independent and don't necessarily need economic support, but IRCC likes to see, money moving around between the couple. So basically, it's usually the sponsor who ends up sending money to the sponsored person, but not always. So they just like to see that, there's some kind of, financial support going on. Attitude and conduct regarding children. Again, not all couples will have this as part of their relationship. Some couples are older and, are beyond having children. Other couples may just not want children. So it doesn't have to be present, but the idea is that you would have the same opinions, you would feel the same way about it, and you would have some kind of consensus on what your attitude towards children and having them yourself are. And then there's the societal perception of the couple. So this is, about the people who actually know about your relationship. So these could be family members, they could be friends, they could be coworkers. They basically want to know that, your relationship is not just two people who, never really do anything, never have any kind of, outdoor activities or public activities. You don't really have any friends in common. This is how they tend to prove that the relationship is genuine, is that other people are aware of it. And again, depending on the situation, it might be more limited. In other cases, it might be, more of a well-known fact. So not all factors need to be present, and those that are can vary in degree. As I mentioned, couples may not have children, and shared shelter may be impossible depending on the circumstances. So eligibility and restrictions. Who can sponsor and what limits apply? So I'm not going to go into details on this because I think Sana did a really good job this morning. But just in, bare bones here, the sponsor must be a Canadian citizen or permanent resident, must be at least 18 years of age or older. The standard sponsorship restrictions apply. So if the sponsor sponsored somebody else and they still have an undertaking in effect, so they maybe, married 3 years ago and are still financially responsible for that person, they would not be eligible. Again, the welfare issue. So if the sponsor is receiving money from welfare, they would not be eligible to sponsor. Those kinds of things, they apply across all three categories. The sponsor also should not have any limitations that would disqualify them under the family sponsorship rules. So again, that might be the bankruptcy. It could be, a record with domestic abuse, that kind of thing. And if they are legally married to someone else, they must have lived separately and apart from that spouse for at least 1 year before the conjugal relationship is recognized. So if that's the case, you would have to wait for the 1 year and then think about applying as a sponsor of a conjugal partner. For the sponsored person, there are similar requirements. They must be at least 18 years of age or older. They must be residing outside of Canada. Inadmissibility rules apply. So these are the same as for all family sponsorship types of relationships. And just to give you an example, if the sponsor came to Canada as an individual, for example, but was really married and did not declare that person, and then later tried to sponsor that person as a conjugal partner, that person would be inadmissible because they were not declared, they were not examined, and the sponsor would also be in trouble. So this is where these inadmissibility rules around the family KLAAS come in. As well, for the sponsored person, if they are legally married to someone else, the same separation requirement applies. This is often the more common situation because in many countries, people cannot get divorced, even though they do separate and they live separate lives. So you just have to make sure that the separation has been for at least 1 year. Okay, some special situations. These are a little bit harder to assess, so I'm not going to go into a lot of detail because they're not quite as common. But if persecution prevents cohabitation, so this would be in the case of people from the same country, living in the same country, and maybe, one at some point comes to Canada, perhaps as a refugee or through an economic program. They could try to apply as common law. They could be treated as common law. It's probably going to be more common with refugees, for example. So it would just be that they would include them on their application. In most other cases, they would have to become a permanent resident and then apply to sponsor their partner. So just examples of things for persecution, fear of persecution, state or social sanctions, ostracism, loss of employment, an inability to find shelter, even where relationships of whatever type are not technically illegal. So, I mean, they don't have to be same sex. They could be, different ethnicities or different religions, that kind of thing. But it's a very, limited and it would be a very special situation that would have to be assessed. Okay, so now on the fun part that usually helps people get a sense of what really would be applicable here, cases that shape this area and how the law has evolved through real decisions. So the first one is actually a bit of an older case. It's about 20 years old now. This is Leroux in Canada from 2007. And this was a case of a gay couple. So a travel agent from Canada met his partner in Morocco during a business trip. And he actually traveled back and forth about 3 or 4 times over 18 months. Now, because the partner was in Morocco, they didn't think that he would be able to get a temporary resident visa to come visit him in Canada. So they decided to do a conjugal partnership sponsorship. And they started this about 1.5 years after the relationship began. So the IRCC officer found the relationship was not genuine. The Immigration Appeals Division at the IRB found it was genuine, but that there was no conjugal relationship, which is interesting. And what came out of this case was, and this is the important takeaway, the M and H factors, so those 7 factors that assess a genuine relationship. The court noted that they were developed for Canadian couples and must be adapted for couples living in different countries. So essentially, context matters. The legal and social environment the couple lives in affects how all factors are weighed. So this is where, the court said they didn't all need to be there. They could be present in different, in different ways and that kind of thing. So this is kind of one of the bases for conjugal partner sponsorship. Carrier in Canada is a little more recent. The decision itself is very short, so it doesn't have a lot of content to it, but the IAD, so this is the Immigration Appeals Division at the IRB, confirmed that an impediment to marriage is not required when the relationship is genuine. So you'll still see on the checklist, though, that you have to provide a reason why you're not married or living in a common law relationship. But the court or the tribunal has actually ruled that it's not required. And there is no stated requirement for an impediment to the definition of conjugal partner. The definition does not ask why a couple has not married. It only asks whether a relationship is real. So that's the main thing to focus on here. And the absence of a formal barrier is not a reason to refuse if the evidence shows genuine commitment. So they're moving a little bit away from that, actual impediment to marry or live together. AP in Canada, again, a little more recent. I think it's from 2022 or 2020. I can't see because there's stuff on top of the slide, but AP was a gay man with refugee protection in Canada. And after his refugee claim was approved, he actually traveled abroad, not to his country of origin, but to meet up with a close friend whom he'd known from school. And they spent time together as friends. And during the trip abroad, she became pregnant. So they had a relationship and they committed to raising the child together. So they applied as a conjugal partner to bring her and the child to Canada. The application was refused. The Immigration Appeals Division dismissed the appeal, but the federal court allowed it because what the federal court found was that the M and H factors did apply to mixed orientation couples, even where neither partner identifies as bisexual. So again, the factors must be adapted to the context, and there was evidence of a committed relationship and financial support was enough. This is actually an interesting one. This is Wagner in Canada, again, 2021, so fairly recent. So the sponsor was a Canadian citizen. She was a school teacher who met her partner in the Dominican Republic in 2008. And she traveled to the Dominican Republic during school breaks for over 10 years until the pandemic and family illness changed her pattern. And the reason she applied to sponsor him in 2018 was because of this, this problem with having conflicted ties between her family and her partner. She wanted to take care of her aging parents, but she also wanted to spend time with her partner. And the application was refused because there was no impediment to marriage or cohabitation. So prior to 2018, when she retired, she couldn't actually live in the Dominican Republic because she had the commitment to her teaching career. After she retired, she had the commitment to her parents. And she also did not like the institution of marriage. So she just didn't want to get married. And that's why they never married. So by the time the appeal went to the Immigration Appeals Division, they had been together for over 12 years. They had a history of continuous visits. They had shared property. She and the partner owned property in the Dominican Republic, and she was providing financial support. So they met a lot of the 7 M&H factors there. And what the IAD ruled was that the reasons for not marrying are not irrelevant, but they're not determinative either. So you're going to have to explain the reason you don't want to get married, but it's probably not going to be, the thing that makes a decision on the application. What they're really looking for is a genuine long-term relationship, which this particular couple had, and evidence that they, had property in common, continuous support, so the relationship was ongoing. This is the most recent one that I've come across so far. This case was also interesting because Vincenzo Rosso was the sponsor and his partner Giselle Mora Alvarez was the sponsored person. They had actually visited each other in each other's countries. So he had gone to Cuba, she had come to Canada, and they did not marry in either country. Now, they had planned to marry in Cuba, but he was born in Italy and he had difficulties obtaining his Italian birth certificate, which is what Cuban authorities needed to have a marriage legal. And they didn't marry when she came to Canada because she came on her own and her children were not able to attend. So they just kind of left it, went back and forth for a few years. And at some point closer to the pandemic, he was tied up with business. He seemed to have traveled for for work and things like that. So he just wasn't able to spend a lot of time in Cuba during those years. Again, the Immigration Appeals Division found the relationship was sufficiently marriage-like and the practical obstacles to their marriage were accepted. So, right, first of all, he couldn't get his birth certificate, and then she wanted to have her children present when they got married. So they accepted those reasons. The gaps in their visits were explained through his work and travel in a family emergency. I think it was on her side. So basically, real life can get in the way of legal formalities, but you need to explain it. You need to be able to demonstrate it. So when you're building your application, what to document and why it matters. Again, a lot of this goes back to what most people would be providing, whether it's a marriage or a common law relationship. So it's not based on it's based on objective evidence, not what you say, but what you can prove. So it doesn't really matter, how genuine your relationship is if you cannot prove that it is. IRCC will refuse it. So again, just skimming the surface because I know Sana went over this morning. Proof of ongoing communication, so messages, emails, call records, evidence of visits, travel records, photos, hotel stays, boarding passes, financial ties, shared bank accounts, which is often difficult between two countries, but if it's possible, great. Money transfers, don't get rid of those money transfer receipts, keep them. And joint property ownership where possible. Again, not always possible depending on the circumstances. Again, evidence of a commitment, and this might be, something that you could put in an affidavit more than something you could prove through documentation, but it could work too through documents. So if you decided to buy a car or a house or, something like that, and it has both of your names on the order or the title deed, that would be acceptable. Again, support during hardship, that would be something that you would be able to explain more in an affidavit than through any kind of other concrete proof. And your plans for the future. I mean, just having, some kind of coherent plan that both of you share. Sometimes when IRCC interviews couples, they have different plans and then IRCC wonders what's going on. So just making sure that you're on the same page there. You also, even though it's not definitive, you do need to explain why marriage or cohabitation was not possible. Your explanation itself probably won't be the thing that an officer will refuse on, but they do want to know why. So they do want to know, some reason why you chose not to marry, if that was possible. And if you couldn't marry and you still could not form a common law relationship, they would also like to know that. Basically, the more evidence you have, the better. These types of relationships can be more difficult to prove, and gaps in evidence need to be explained directly in your application. So, if there's something that, you think an officer would wonder about, you should probably explain it. Okay, so just some key takeaways to wrap up. Conjugal partners exist for couples who cannot marry or live together. The M&H factors assess relationship depth, and not all need to be present. Recent cases have moved the strict impediment to marriage or common law requirement, and a genuine relationship is what matters. Thorough documentation is essential, so basically the more evidence, the better. And if you think this might apply to your situation, you probably want to get advice from a licensed immigration professional, because it's not as obvious or straightforward as marriage or common law partner. So thank you for listening to my presentation. You can follow or connect with me on LinkedIn using this QR code. I don't use any other social media, so this is the best place to connect with me. I'm also offering 20% off a 60-minute consultation with coupon code SUMMIT2026, which expires at midnight on June the 12th.
All right. Thank you so much, Carolyn. That was really, really good. Let me just pop this information into the chat so people can click Summit 2026. All right. Okay, so I popped this information in the chat. If you want to get in touch with Carolyn, you can go on her website. You can use the promo code. You can also just type Carolyn Watson name in Google and DM her on LinkedIn. All right, so let's see if we have any questions to Carolyn or otherwise, because now we're going to be opening the question and answer period for the day. Okay. Let's see. Okay, so I'm going to maybe ask some questions like that we've had on. Oh, I think 1 second. What was the final result of the first case study?
Oh, let me go back and see which that was. That was the row, right? Yeah, so that was way back in 2007. So this is, quite a long time ago. Things have changed quite a lot. Yeah, so what the federal court does is it doesn't actually make the decision. It just says that it needs to be redetermined. So it was sent back to an officer for redetermination.
All right. Okay, given so I have like my question just because again, it's a little bit of a I know that there are people out there that are applying for conjugal sponsorship, and they don't really have any crazy circumstances. They would just say, so like one example I literally just have from our YouTube channel, and the person, just commented and we chatted with them on a YouTube channel saying that like, hey, I just have a boyfriend, like he's in Australia, I'm in Canada. Right now we cannot be together because of this and that reasons, like very just like life reasons, right? Yeah. And like nothing crazy is happening. And then, we applied and we got approved. Have you seen cases like that you would think that otherwise like would really not, supposed to be like that easily approved, just like we're a boyfriend and girlfriend and it's just, that's it. We just live in different countries. What would you say?
Yeah, I mean, sometimes, I did meet with someone a few months ago who had a similar situation. I mean, there was kind of a reason that one of them couldn't really travel. So, that's a bit different. But I mean, I think it depends, right? Like people have careers, people have things that they're committed to in their country, where they live. I think if you can demonstrate that effectively, that's a pretty good reason for not being able to come and just relocate yourself for a full year. Again, like with Wagner, one of the last cases they talked about, she was just opposed to marriage. She just didn't want to get married, and that would have really solved her problem quite early in the relationship. But if you don't want to get married, you don't want to upend your life until you know that you can actually build a new one. I don't think it's wrong. I just think that you would have to, put a lot of effort into demonstrating why and proving why you would opt for this option rather than something a little more straightforward.
Yeah, yeah, for sure. We have not had an easy experience in our firm with conjugal relationship. We've had very, very complicated conjugal relationship cases where IRCC, even with those excruciating circumstances, was really tough on applicants. We've had a couple from Afghanistan at exactly when Taliban came, and like Taliban was there, and they sent the sponsor back to Afghanistan to get married, and they said we will not approve the application until they will get married, even though we applied as conjugal relationship. So, and I mean, like that was like pretty serious, and we've submitted like hundreds of pages of proof and everything, and it was really tough time at that specific moment for for everyone, for the couple. And I'm like, how are you sending somebody to Afghanistan? I don't know, but that didn't seem to be easy for me. So that's why.
That's probably more of a typical case. Like that would be where you would definitely want to be using it. I don't know. I mean, appeal, like I think that might be something that would get through on appeal depending on what their concerns were, but
They ended up getting married. So he did travel to Afghanistan, and they ended up getting married. We just submitted marriage certificate, and they technically the case was still approved as a conjugal relationship because that's how we applied. But so they're all approved and fine. But it's like I just want to point out that it's not just as simple as like, hey, we're boyfriend and girlfriend, right? Like they will question that, yes.
Yeah, so you do need to provide a lot of evidence, right? Like it can't just be, this is our best option.
Exactly, yes. Okay, can you explain situations when where divorce is not recognized? Couple have long distance relationship, divorced couple separated more than 1 year ago. Would this be considered conjugal? Would have to prove why can't live together. Yeah, so I guess it's just when the divorce is not recognized, it is like actually a pretty common situation.
Yeah, this actually is really common. So I mean, yes, you would have a long distance relationship, but you would also have, evidence that you do spend time together or that you have spent time together if there's a break in that that habit for a while for whatever reason, like illness or work or something like that. So you would still have to demonstrate that you do have a genuine relationship with the person. I'm assuming the person who can't get divorced is the sponsored person, so the person abroad, which is quite common. Again, you would just need to prove that if you can't get divorced, that you actually are living separate and apart from that person for at least 1 year. I know a lot of places they just go their separate ways. They don't bother with annulment, they don't bother with divorce, they can't do the divorce, so there's not often a lot of paperwork, but sometimes you can demonstrate that you've changed houses. Sometimes depending on your relationship with your ex-partner, you could have them do an affidavit just saying that you both separated on this date, you've lived separate and apart from that date. There's a lot of ways that you can demonstrate this. It would really be specific to your situation, but the main thing is that you are living separate and apart for at least 12 months, and then you would be eligible to be identified as conjugal partner.
Yeah, for sure. Okay, like let's dig into some earlier, oh, we have one more. Yeah, no problem. With some earlier questions, because I know we had some of them that we didn't cover. Let me see. Okay, this is the one I believe we did not cover. If someone is out of status in Canada, and their spouse becomes a PR through express entry, declaring non-accompanying spouse, can this spouse later be sponsored? Lots of moving parts here. Anybody wants to take this?
Sure, I can take it. Why not? Let's dig in. So, I'm of the always I think that everywhere is a problem, there has to be a solution. So I would absolutely say that yes, there is a way to do this. First of all, the fact that the spouse was non-accompanying in the express entry application has to be addressed. Being a non-accompanying. Secondly, was the spouse medically examined? That's a big thing, right? Because even non-accompanying family members, any type of PR application has to be, they have to be examined. So I'm pretty sure there were some circumstances there, right? Because who wouldn't want to declare their spouse on their express entry profile? So as long as that is explained in your spousal sponsorship application, and as long as it's a very good reason, I'm sure it probably is, I don't see why something like this can be successful.
Yeah, exactly. The part of out of status doesn't make sense to me because, maybe because like if you are out of status and your spouse is currently getting a PR through express entry, then that ultimately would affect that person's PR, right? Because you cannot just be married to somebody out of status and not be affected of it, because it would be an inadmissibility for both of you, depending on how long out of status and all that kind of stuff. But I just would agree that, in certain circumstances that can actually like fly pretty well. It's just obviously you understand that it's not super straightforward situation. It needs to be navigated carefully. But I would say I don't think we actually touched today on out of status sponsorship. The general thinking about it from people is that like, oh, I'm out of status. And some people, out of status for like 10 years, right? Like for long periods of time. And they would think that it's like actually, like super complicated application, when in reality, surprisingly, it's not. You just say that I'm out of status and that's it.
Correct.
That's true. That's true. However, you have to demonstrate that you didn't enter into the marriage or relationship because of that. So that's the biggest thing, right? Because it kind of looks like it, depending on the timeline there, right? And I want to address one more thing, if I may, about couples where divorce is not recognized, because I actually worked a lot with people from the Philippines, where once you get married in the Philippines, that is for life. It takes like years and years and tens of thousands of dollars to divorce in the Philippines. So there are actually two routes you can go about it. One is indeed the conjugal partner. The second option is you can file for a divorce in Canada if you have been a temporary resident in the same province in Canada. Now you have to have grounds for this, and typically is the breakage of marriage. You are not in a marriage-like relationship with your spouse in the Philippines for more than a year. Clearly, you're in Canada, right? For more than a year, so that makes sense. So that will allow you to be seen as divorced as in the eyes of the Canadian law. However, the divorce granted in Canada is not recognized in the Philippines. So this is super, super niche, I know, but I know people struggle a lot with this, people from the Philippines.
Yeah, for sure. Virginia, you wanted to add something?
Yeah, I was about the previous question about out of status in Canada and declared as non-accompanying. I think we must pay attention to non-accompanying member being in Canada. So this can be the trick part of the situation, because as you said, if you are not out of status, there are ways to mitigate that situation. But you say that the person is not coming with you, but the person is already here. That is tricky. So you have to see the whole situation. Is something that you have to evaluate in detail, but must be careful with this point of my opinion.
Yeah. Absolutely. Yeah, I know that at our practice, we're very careful with that because it's a bit tricky. Yeah. So yeah, definitely needs to make sure that think about it. All right. So we have another question along the same lines. So if you didn't declare your spouse to be on IRCC Express entry, and then, can we sponsor them later, and how much time it takes? So, or for example, like if you got married in the process of express entry. So can anyone like kind of speak to that? So that connection, express entry to spousal sponsorship. And then if anyone can please explain the difference between non-declaring your spouse before getting an invitation to apply and applying, and then non-declaring your spouse actually after applying, because those are two different things, right? So anyone wants to take that whole topic? No?
I think it depends in which phase of the application you are. So if your application is ongoing and you get married before the approval, you just communicate and include your spouse on the application. This is something it's quite easy to do, and it works. If you can prove everything that the relationship is real and all the situations. I had a case that was even a arranged marriage in India, and with all the documentations, it's passed. It delays a little bit, but it's done. But it's very important to understand why it was not declared and when the relationship starts, because this is going to change everything. And
yeah, exactly, because we've had a case, well, it was not a case, it was just somebody who attended one of our events. And basically what happened is that the person applied for express entry, and then, got COPR, got confirmed as a permanent resident, and they got married, or they actually, to complicate it a little bit more, they actually hit common law status, not marriage. They hit common law status like a couple of days before COPR was issued. So then they turned around and applied for spousal sponsorship, and that spousal sponsorship received PFL saying that you actually became common law partners before you received permanent residency, meaning that you did not declare that common law partner, and that means that your common law partner was not examined during your permanent residency process, which means that you were refusing spousal sponsorship. And I actually don't know what happened next. It was not our client, but what happened next, because what can happen, they can actually reopen PR application of that person and say that you misrepresented your case, right? Or because your spouse was not examined, right? Because that is possible as well. So you have to be very careful. And as Virginia mentioned, is that it's honestly with express entry, it's all about timelines, because it matters if you are married, to answer the question, before invitation to apply and before you submitted application, or you got married after you submitted application for express entry. That really would affect your spousal sponsorship process. So I know it's confusing, guys, but honestly, yeah, it needs to be navigated properly. All right. Do you guys see any other questions in the chat that you want to pick up and answer? Maybe we can speak a little bit about like processing time. Because I saw a couple of people asking processing times, generally, like just general kind of idea, and how long it takes to get AOR. Anybody wants to speak on that?
I received an AOR today for an application that I sent in February, so it was not so bad.
Well, I don't know, 4
Awesome.
months still. It's
Oh
pretty
yeah,
significant.
we are already in June. Forgot. Sorry. Yeah, 4 months. It's
Yeah,
going
like
so fast.
4
Yeah,
months. Yeah.
yeah. It was a spousal sponsorship application, so it's different for express entry. I understand the situation, but it was 4 months. And the processing time, it depends on which program you applied for. So express entry is, some cases I got with 4-6 months. It depends if you have complications, it can take longer. The spousal sponsorship, we know it's about 15 months, depending if it's inland or outside. Quebec, forget. Life is a mess.
Quebec, just forget about it.
Yeah, don't ask that. No
Yeah.
processing time. So it depends on the application.
Yeah. Okay, anybody wants to take this spousal open work permit question from someone who really wants to get their answer? I know it's not the topic of today, but if anyone can take that question, it's in the Q&A box. Last question.
Which is the question? Sorry.
So I can read it out loud. So my girlfriend is in Calgary under a postgraduate work permit. We've been together for 6 years, but we haven't had the chance to live together since our relationship. I visited her last November 2025. I went home last March 2026, since I have only a visitor visa. So the person is visitor visa. My question is, are we eligible for a spousal open work permit? We do not know what steps to take because it seems that our situation is complicated. Can I go to Calgary, get married right away, and apply for spousal open work permit? If so, am I allowed to work while waiting for results?
That's a tough nut to crack. I'll start there, and maybe we can all pitch in. I'll start by saying that first of all, it depends. Your girlfriend, what is her job, right? What position does she have, right? To qualify for a spousal, first of all, open work permit as a postgraduate work permit holder has to be a specific tier, a specific NOC. Not all spouses qualify. So this is the first part, right? It's very different. if your girlfriend works, for example, at tier 0, tier 1, or a 3, or a tier 3, 4, 5, and so. And that goes all the way back to the knock codes and how Daria explained yesterday during the express entry presentation, how you actually determine what knock code is your girlfriend job, does a girlfriend job fall under? Not just the title, the job description. This is the first part of it. Secondly, even if you come to Canada, marry her, and apply for a spousal open work permit, how you have to prove that you didn't just marry her because of the spousal open work permit. So you have to have a really, really good reason there. Why didn't you do it before? Why didn't you marry her while you were in Calgary on the visitor visa? Why right now? So that would be my 2 cents on it.
And there is
it's risky. It can go through, but
Yeah.
Sorry, go ahead, Virginia.
Sorry. Don't forget that we have to see when the PGWP expires, because now there's that rule that it cannot be less than 6 months of
Yeah.
PGWP. So, and because today he doesn't qualify, if he gets married, as you said, you have to explain why in 6 years, just now you are getting married. And yeah, it's
Yeah, that's true. Actually, with this case, I would take the long and winding road and safer road. Let your girlfriend apply for PR because that's technically the next step, right? After she meets the requirements under her postgraduate work permit. And then, you can be, if you guys get married in the meantime, you can be an accompanying spouse on her PR application. And I see this way cleaner. It might take longer, but it's at least a cleaner route to take.
Yeah, I agree.
Yeah, sounds good. Now I can see that several people is asking for options for French speakers. So just a reminder that tomorrow is our day three. We are having a presentation from Lawrence, and she will be talking about PR pathways for French speakers, which we can all agree are very good right now. So if you are a French speaker, make sure that you attend tomorrow, because honestly, having a French language is just gold when you're trying to immigrate and settle in Canada. So make sure you attend tomorrow's session. We will be covering all of it. And Lawrence, always such a fun presenter. I'm sure you will enjoy it. Okay, anybody has any more questions that they've seen in chat or in the Q&A box that they would like to answer? Oops. We have one question in Q&A box. So long story short, boyfriend and girlfriend are dating for a very long time. They spend every weekend together. And but they're not married and they don't really live together, but they've been dating for a very long time and they spend a lot of time together. Now, the person that's asking the question is going to apply for express entry and get a PR through express entry. So they're asking is that, we're not technically common law since we don't live together. So as far as I understand, I don't need to include her in my express entry. Is that correct? That's one question. Another question is that once I get my PR through express entry process, can I sponsor my girlfriend? And I marry her. They're planning to get married.
Well, I can take a stab at that.
Yes, perfect.
Right? Okay, it's all about eligibility. If they're eligible, right? Like you gotta, like right now, they're not eligible as common law, or a married couple, they're not eligible. So that's the first barrier. He could, if he sees this like brewing in the future, like in his letter of explanation, he could drop a line and be like, you know, I have a girlfriend and we're not common law yet, but I'm in a relationship, you know, that I see potential to get married. And then it's not like, you know, like you didn't declare her, but you did, you know. So again, what Cosima said, that like, you know, you're answering the visa officer's question of like, oh, why now? Why wasn't she included? Why didn't you declare her before? Or, you know, and this is the funny thing about about common law, because you have to, you could be living with your partner for 3 months, 4 months, 5 months, 10 months, 11 months, and you're not common law yet, but you're in such a close relationship. And like the example you stated before, where the dates mixed up and they became common law relationship like right before, but really there was nothing to declare before, yet there was so much to declare. So it's a tricky scenario. But
Yeah, you just have to be careful about your dates. Yeah.
Mhm.
But generally speaking, let's just say if you're not, let's imagine you're not planning to live together at all, because in a lot of cultures, that's the thing, right? Like you cannot live together. You can date for however many years you want, but you cannot live together. And then when you're married, then you move in together. If that's a situation and this person gets a PR through express entry, then it's fine. Then you can just sponsor your spouse and that's okay.
Mhm.
But it's just, I guess, you have to be more careful if you do end up living together before marriage. That's when, you know, you need to be more careful. Yeah.
Mhm. Mhm.
Okay, guys. Well, I think we're going to 3 p.m. here. I think we're going to close down the floor and we're going to have our big Q&A session with all of the speakers tomorrow. So thank you so much. Let's thank all our speakers today, all our panelists. And if you have any questions that have not been answered, we will get to them tomorrow. Tomorrow is our kind of a mix and match day when we will be talking about Canadian citizenship by descent. Love the topic. We will be talking about pathways for French speakers. We'll be talking about Alberta PNP program and about healthcare programs as well. So for healthcare professionals to get PR in Canada. So stay tuned to day 3 tomorrow. Super excited. And we'll take more questions tomorrow. Thank you so much, everyone. And we'll see you tomorrow.